Very good afternoon to everybody. Now we should start. You're all waiting for the finals now. How excited are you? Not really. I think I'm louder than you, no? With so many of you, you should be loud, young people. No? Yeah, I think. Yes, tell me how excited are you today for the finals? All right, I think we should start.
Good afternoon, everyone. Welcome to the final round of the 20th KK Luthra Memorial Moot Court 2024. We are the court masters for this courtroom. Judges, we will be assisting you throughout these proceedings, and we are extremely delighted to have you with us today. Judges, we'd like to bring your attention to the judges folder, which contains the moot compromise, the memorials of both the teams, as well as the score sheets on which you will be marking the participants. Judges, please note that the participants have to be marked out of 80 and not 100, as they already have been marked for their memorials. Judges, if you're ready, may we commence with the proceedings? Judges, please note, Speaker 1 of Team URN 2220 will speak first.
Much obliged. Good afternoon, your lordships and ladyships. I am Counsel 1, and along with Counsel 2, we represent the petitioner in the present case. Your lordships, in the present case, the petitioner, that is Mr. J.J. Crook, had been detained and arrested, and we shall prove that this was without any rightful authority on behalf of the state of Crete. Addressing the issue 1 and 2 will be my duty regarding the immunity of Mr. J.J. Crook being a diplomatic member, as well as the inviolability of the mission premises. Issue 3 and 4 regarding the evidence and remains subsequent to the confessional statement will be dealt in detail by my co-counsel. Your lordship and ladyships, addressing the factual matrix involved here, the detention was done without any regard to diplomatic immunity, and it will be proved that Mr. Crook is in fact liable to be given the immunity under the Vienna Convention. Both the states, that is FOA and Crete, are signatories to Vienna Convention on Diplomatic Relations. This convention outlines the immunities and privileges that are to be given all to the members of a diplomatic mission. The foreign mission in Crete, that is the embassy here in the case, had many members across the ranks. Your lordship and ladyships, under the Article 1E of the convention, if your lordship and ladyships may come. To page 2 of the compendium.
To your memorial.
Yes, your ladyship. As well as the Vienna Convention, if a copy can be provided.
All right. Yes, we've got it. Thank
Your ladyship, under Article 1E, the definition of a diplomatic agent is given. It says that a diplomatic agent is a head of the mission or a member of the diplomatic staff of the mission. Thereafter, another definition is given under definition 1F that talks about administrative personnel and technical personnel. Your lordship and ladyships, the argument flows from the ground that Mr. Crook is entitled to the categorization under Article 1E. The basis for this is the Vienna Convention. The Vienna Convention on Diplomatic Relations was based upon the functional necessity theory to essentially give immunities to people to ensure the smooth functioning of the mission. Here in the present case, Mr. Crook is not just a private bodyguard or servant. He's the head of security as well as ambassador's bodyguard. This has already been outlined in the submissions of the state as well. Further, he has had dealings with confidential material relating to national security of FOA as well as Crete. In this regard, it is submitted that the immunity and categorization that ought to be given to Mr. Crook would be under Article 1E of the convention, that is of a diplomatic agent. Further,
So you were saying he will fall under 1E.
Yes,
That's
your
your
ladyship.
emphasis.
Yes, your ladyship.
And not 1F.
No, your ladyship. I shall prove further as well.
Let's see
Yes,
how
your
you take us there.
Yes, your ladyship. Your ladyship, reiterating that the functional necessity theory, the purpose behind was this, essentially, that the state must not exercise jurisdiction where it is not its power. In the present case, Mr. Crook has had, when there was an incident in the embassy, the ambassador contacted Mr. Crook to conduct an investigation. You wouldn't contact a private servant to do an investigation which has regarding the prime minister or the prince of your home country. This shows that the duty cast upon Mr. Crook places him on a higher pedestal in the functional necessity theory. Further, the designation that is given to a member, it's the discretion of the sending state. The receiving state, under Article 7 of the Convention, the sending state is free to appoint anybody in any rank, provided there is approval from the receiving state, which in the present case is. Furthermore, going forward to the submission.
Just 1 second, sorry to interrupt you, but tell us, was he ever labeled as a diplomatic staff by the state? No.
No, Your Ladyship, there was no specific.
How does that help you when you say he was free to do it? Free to do, the state was, no doubt. They are their employees, the state is free. But you are also admitting that this Mr. Crook was never designated as a diplomatic staff
Your
in
Ladyship,
terms of 1E.
Your Ladyship, the designation is not material record regarding every diplomat.
No, we were only responding to your submission. So we were thinking, why are you making that submission that the state has the choice to decide whom to designate as what? But you are yourself admitting that he was never designated.
Your Ladyship, the designation is not provided.
All right, you can proceed.
Yes, Your Ladyship. And further addressing Your Ladyship regarding the immunity and privileges under 1E that will be provided to a diplomatic agent. Now, Mr. Crook is a Cretan citizen. That is, he's a citizen of the receiving state itself. So the immunities and privileges are outlined in Article 38 of the Vienna Convention. If Your Ladyship and Lordship is with me. It's on the page 5 of the compendium.
Proceed.
Yes, sir. Your Lordship, under Article 38(1), it specifically says, except in so far of additional privileges and immunities may be granted by the receiving state, a diplomatic agent, that is under Article 1E, who is a national or permanently resident in the state, shall enjoy only immunity from jurisdiction, that is the jurisdiction of Crete, and inviolability from any arrest or seizure in respect of official acts performed in exercise of the functions. Addressing the caveat of official acts, Your Lordship and Your Ladyships, Mr. Crook is not merely a security person. He's in fact the bodyguard of the ambassador itself. It would not be out of line to mention that a duty of a bodyguard is essentially to protect the person, and any means necessary may be used, especially since under the factual matrix of this case, Miss Penny was well versed with defensive capabilities and she was aggressive at the time of the acts that were committed inside the embassy. In those circumstances, the duty upon Mr. Crook to protect the ambassador is in fact his official duty.
But
and
how do you explain that this duty goes how far-fetched it can go?
Your
The
Ladyship,
duty is to protect, no doubt. Self-defense is all right.
yes, Your Ladyship.
Or defense, in the larger sense, defense of the ambassador. But killing somebody, will that fall within the duty of your exercising your right of self-defense?
No, Your Ladyship, the specific point regarding killing someone outright would not fall. However, under the factual matrix, it was not the intent to kill the person. It was merely to protect the ambassador itself. It was a defensive point rather than an aggressive statement on part of Mr. Crook himself.
Just very simple clarification. You refer the Article 38, Clause 1.
Yes, Your Lordship.
The immunity in respect of the official act.
Yes, Your Lordship.
But to kill someone, to murder someone, whether it can be covered under the official act for which the immunity can be claimed.
Yes, Your Lordship. So, addressing the official act aspect, as reiterating that Mr. Crook is in fact a bodyguard. Now, a bodyguard's duty would extend to protecting the person he is entrusted to by any means necessary. And in the present case, the means were exercised against the aggressive nature of
No
Mrs.
doubt
Watts.
about it. He was under an obligation to protect the ambassador as well as the king who was coming as a chief guest in the program. But to kill someone, to brutally murder someone, whether it can be well covered under the color of official act,
Your Lordship, the factual matrix regarding killing someone is still has not been proved in its entirety. The state has not able to prove, there are no evidence on record, any forensic evidence, the dealings of which will be done by my co-counsel. There is nothing on record to even show that.
So you can skip that point. That
Yes,
whether there is evidence at the moment, the question is premised on the fact that whatever evidence is there, inadmissibility or cope.
Yes, Your Ladyship. So, submitting it up on the point of official acts, it would be well within his duty to protect the ambassador by any means necessary under the nature of the circumstances, given the aggressive nature of Mrs. Penny Watts. Now, if I may proceed to issue number 2.
Yes, yes.
Oblige. Your Lordship and Ladyship, issue number 2 deals with the inviolability of mission premises. On the day of the incident, next day during the investigation, Detective Inspector P.V. Bain went to the embassy to investigate the case. However, he was denied entry explicitly. There is no ambiguity regarding the rejection of entering the premises. Thereafter, Mr. Crook suddenly heard some sparks emanating from the embassy premises, and he went into the embassy, forced his way into it, despite protests of sovereignty by the members of the embassy. Your Lordship and Your Ladyships, I draw your attention to Article 22 of the Vienna Convention.
Yes, Article 22.
Yes, Your Lordship. Your Lordship, under Article 2, the premises of the mission shall be inviolable. The agents of the receiving state, which also includes law enforcement authorities, may not enter them except with the consent of the head of the mission, that is, the ambassador. In the present case, the consent was expressly rejected. That could be argued on their front regarding a caveat under Article 22(2), that they are under a duty, a subordinate duty rather, to protect the embassy premises. However, that argument would not be material to the case because there is no clause that says without prejudice to Article 22(1). You cannot say that to protect the embassy under Article 22(2) will violate your inviolability, which is absolute in its entirety under Article 22(1). That would essentially defeat the purpose. Thereafter, addressing the claims of fire. The claim of fire is very questionable in the present case. The fire that was cited to gain entry into the premises, thereafter, there is not a single mention of the fire in any reports or any statements. If you're claiming such a fire and gaining entrance into such a sensitive area of international importance, you ought to have something on record to show what efforts did you take. The the police officer directly went to the server room and the investigation proceeded from them. However, there is nothing on record regarding the fire. Was fire brigade called? Was there any fire extinguishers, or was a report being made? There is nothing on record regarding that. So the claim of fire is itself a dubious claim. Addressing the point of skirting the lines, the past conduct of Detective Inspector P.V. Bain is also highlighted here, that he was recently transferred to this police station. Earlier, he was an inspector at the railway station police department, and therein he was alleged to have taken bribes and extorted money from the workers. So the past conduct showing a pattern is extremely relevant in the present case. That implies that skirting the lines is not something beyond the character of the investigating officer. Thereafter, I'll address the exception.
Just 1 minute.
Yes, Your
Even
Lordship.
I entered into the premises of the embassy under the garb of some sparking and a fire. But I was under the impression that vital evidence can be collected related to the crime. I'm not saying whether the crime was actually committed or not committed, but first it was the stage of collection of evidence.
Yes, Your
So
Lordship.
whether in this circumstances, again, you can claim inviolability, not to
Yes, Your
enter.
Lordship, and I'll walk Your Lordship through how that inviolability extends. So, Your Lordship, under Article 22(1), you cannot gain entrance into the premises without consent. That has been breached. So, once the entrance was gained, there was search and seizure. They went into searching into various rooms, including the ambassador's room. That in itself would violate the inviolability under Article 22(3), that says that the premises of the mission, their furnishings, other property thereon, shall be immune from search, requisition, attachment, or execution. If Your Lordship is with me.
Please
Yes.
continue.
Yes, Your Lordship. And regarding a potential argument that would come up that there is an implied exception, that it is a case of emergency, we ought to have entered it. there is a differentiating element with the Vienna Convention on Consular Relations and Vienna Convention on Diplomatic Relations. The former deals with consulates, whereas the latter deals with an embassy. The difference is merely administrative passport work is undertaken in a consulate. It is less important in the scheme of international relations as compared to an embassy. And there exists a fire clause, or rather an emergency clause, under Vienna Convention on Consular Relations. But that does not mean that the same can be read into the Vienna Convention on Diplomatic Relations, especially when there is an express bar to gaining an entrance into the same. And your lordships, addressing the evidence and rather the further search and investigation done by the investigating officer within the embassy, that is another violation under Article 24 of the convention, if your lordships may come. Yes. Your lordships and your ladyships, under Article 24, the archives and documents of the mission shall be inviolable at any time and wherever they may. This provides a very expansive definition to what archives could be. And to draw an analogy, the Vienna Convention on Diplomatic Relations is very silent on the definition of archives. But when we compare it with the Vienna Convention on Consular Relations, it elaborates and says that videotapes, recordings, and digital means are also included into the definition of archives under the Consular Act. However, it would be absurd to say that a Consular Act has a better definition than an embassy. In that regard, the archives and all documentation is in fact another violation, notwithstanding the inviolability of breach under Article 22(1). And addressing a last argument that could be made is under Article 41, if your lordships may come. Your lordships,
Article 41.
under Article 41, it can be argued that the sending state or the members of the diplomatic mission must follow the rules and regulations. However, there is a very clear caveat in the beginning of the sentence that says, without prejudice to the privileges and immunities. That says that even if there is some breach in law, they may try to uphold the law and try to follow the regulations, but them being in breach of anything does not affect their immunities or privileges under the Act in any manner whatsoever. To sum up our conclusions regarding issue 1 and 2, in issue 1, we submit that Mr. Crook is part of a diplomatic agent under Article 1E and is accorded immunity under Article 38(1). Thereafter, there is serious breach on part of the state under Article 22(1) as well as Article 24, my apologies, to investigate the premises, especially when they did not have the authority to do so. In this regard, the further evidential circumstances will be dealt in with my co-counsel. I seek the leave of the bench.
Only one question before you go. We go back to 1E and 1F.
Yes, your ladyship.
You were saying he has to be treated as falling
1E.
within 1E. But if there is a specific clause 1F, that clause has to be given a meaning.
Yes,
Who
your
will
ladyship.
fall within the administrative staff? That's the question.
Yes, your ladyship. To enumerate
Because
on that.
rest of your arguments come later.
Yes, your ladyship. I agree. So
If
under
because what is the law on that? When there are two clauses, they both have to be given some meaning.
yes, your
It can't be
ladyship.
said that that clause is redundant. If
No,
there was no 1F, maybe we would have accepted your plea that all right.
Yes, your
It was for
ladyship.
the state to decide. He was doing something. But you've not touched that point at all about 1D and 1F.
I seek
1A.
extension to.
You can answer the question.
Yes,
that's
your
it.
ladyship. Your ladyship, the definition is not specifically provided, whereas there is no illustration as to who will fall under which category.
That's correct.
But when
that's
we
for the court
understand the core of the preamble of the convention itself, it essentially says for the smooth functioning of the mission. So to give an interpretation to such a clause would be in the interest of the sending state to ensure the confidentiality and functioning of the mission.
I mean, the question was that would it be not too far-fetched to include this kind of a person who's only a security guard of the ambassador under 1E instead of putting him in 1F when there is a specific clause. If there was no 1F, then maybe you were right. But now there is a specific clause describing the other category of persons.
Yes.
Then who will fall under administrative and other categories?
Your
If
ladyship, all
if
the
even
clericals-
a security guard, you are putting him in the diplomatic, in the light of this 1F.
Yes, your ladyship. Your ladyship, under Article 1E, The definition,
complete that.
let me complete, please. Yeah, the definition would include, under article, the administrative and technical staff would include clerical personnel and drivers and gardeners of the embassy premises. That would be technician, for example. However, once we see the duties that are performed by Mr. Cook, he's not merely a security guard. He's the head of security of the 4-1 mission.
Just one very simple question. You refer Article 1E and 1F. I'm not taking them in the isolation and mutually exclusively from each other. Definitely you does not fall in Article 1E. But if the member of the administrative and technical staff are the members, can you still label even the head of the security personnel as a member of the administrative and technical staff as per Article 1F?
If your lordship and your ladyship decide that the categorization would be under Article 1F, then there is international practice in Commonwealth jurisdictions where immunity is given in those regards. And the jurisdictions of Australia and New Zealand both categorically give, which is exhibited in the compendium itself, they categorically give immunity to those people as well. So it would be
security personnel also.
Administrative, technical, private servants as well. Going a step
Not
further.
governed by that. You are governed by this specific
Yes, Your Lord,
convention.
that's what to
Anyway,
enumerate
thank
my
you,
point.
Thank you.
I seek leave of
That's all right. Thank you.
much obliged.
Judges, please note, Speaker 1 of Team URN 2220 has spoken for 19 minutes, out of which 2 minutes is an extension. Speaker 2 of Team URN 2220 will speak now.
It's okay. I can't make out. We are not that scary.
Feel comfortable.
May it please the court, I am the second counsel for the petitioner and I will be dealing with issues 3 and 4. These have to do with the admissibility of the evidence gained from the illegal search and seizure in the embassy and the evidence gained from the confession by the accused, which is the burnt remains of the body. My submissions will exclusively revolve around a principle called the exclusionary rule of evidence. This has been developed by the United States Supreme Court. And by extension, I will also dwell upon something called as the doctrine of the fruit of the poisonous tree for issue 4. What the exclusionary rule says essentially is that any evidence that has been obtained from an illegal search and seizure is to be discarded. The logic underlying this is very simple. The 4th Amendment of the US Constitution is essentially a prohibition. The 4th Amendment of the US Constitution contains a prohibition against unreasonable searches and seizures. And so what the US Supreme Court has held is that if there are no consequences for law enforcement upon breaching law, upon conducting an unreasonable search and seizure, there is no point in having essentially a prohibition against unreasonable searches and seizure. So it is a deterrent measure in that sense. Now, a very important question arises at this stage, which is why should this court, on our insistence, adopt a particular standard for a particular question of law from a particular
That's what we were
jurisdiction?
going to ask you. Why should we follow the US law, especially when the trial is in a European country?
Indeed, your ladieships and the respondents have also pressed for alternative standards which may dwell on the content of the evidence rather than the manner in which it was obtained. So it's very important to answer this question. The answer to this is twofold. Firstly, if this court looks at the footnote on the last page of the Moot proposition, it says that this court has already accepted the American exclusionary rule, but there is some scope for certain scope for clarity. I will dwell on that in detail. But my second reason for insisting that this court accept the American standard is one of principle. And this relates to the classic civil liberties versus public policy debate. And
this question, the exclusionary rule has been very controversial in America as well. The US Supreme Court has had to deal with a whole lot of criticisms, and so it has. And I'll just give one example. This is not a persuasive authority per se, but in a case called Elkins versus United States, and the relevant portion is on page 120 of our compendium. The majority in this case made a very interesting comment. It said that while there may be no empirical evidence for us to claim that the exclusionary rule has affected the administration of criminal justice one way or the other, there is pragmatic evidence there is pragmatic evidence in the sense that no law enforcement agency, the FBI in that case, has ever complained that the exclusionary rule has affected the administration of criminal justice or has proved to be an impediment in any way. And so what the conclusion that we come to is that this is essentially that there is no harm, and that it is also essentially good for civil liberties in the sense that law enforcement is deterred from breaking the law. If that is the case, Your Lordship, if that is the case, your Ladyships and Your Lordship, the American standard must be accepted because it furthers the cause of civil liberties and that there is no harm. Now, I will also dwell upon the voluntariness of the submission. This is with respect to issue 4 and the confession. I will dwell upon the voluntariness of the so-called confession. Now, at the outset, I must state that across various jurisdictions, including in the United States, including in Canada, in UK, across various common law countries, the standard is that the state has to prove on a preponderance basis that the confession is indeed voluntary. So we will leave the state to do that, and we will rejoin in response. But there is a larger point to be made here, regardless of the voluntariness, which has something to do with something that is called the doctrine of the fruit of the poisonous tree, which is that any evidence that is gained from any illegal activity by law enforcement, however down the line it is, which is obtained as a consequence of any illegal action, so in this case the illegal search and seizure, however down the line it is, must be excluded. So in this case, the confession or the statement, if we accept it to be a confession, is a direct consequence of the illegality. This would never have happened if the illegal search and seizure had not happened, and therefore it is a fruit of the poisonous tree.
What do you have to say about the CCTV footage?
Absolutely, Your Ladyship. The CCTV
confession may be all right under duress, may be under whatever you can say. But yes, what about the CCTV footage, which shows a lot? Then your only answer is that American judgment saying
that is indeed my my answer.
Have you compared the Indian position with that?
My lady, the Indian position also has explicitly been rejected by this court. This is also there on the footnote on the last page of the Moot proposition. There are standards which are in between both the extremes, such as in England or in Canada and various other common law jurisdictions. They look at the probative value. They basically say that if the facts are staring at your face, it is not proper to let the guilty escape conviction. However, for all the reasons that I have just detailed, including the fact that this court has already accepted the American standard, and we are a common law country, stare decisis is the soul of common law, and my argument in principle about civil liberties being precedent to vague considerations of public policy. For these reasons, I would say that the American standard must be accepted, and the content of the evidence must not be looked at. What must be looked at is the procedural violations.
Just one question. You were saying fruit of a poisonous tree, evidence collected through illegal means is not admissible. But there are certain countries which are saying that what you have to look at, what are the two fundamental factors to be looked at for admissibility of an evidence? It's relevancy.
Yes.
Right? That is the fundamental. So how would you give in one line one principle to say we will look into the evidence irrespective of the means through which it has been collected?
We will that this court will not look at the evidence.
We would look into it irrespective of the way it has been collected.
We submit that this court should not do that. That is.
What is the fundamental principle? See, fundamental principle is fair play, injustice being not done, and third is the relevancy. These are fundamental principles.
Yes.
If you were to look at the law world over, and if you were to take out one principle, that principle is essentially the relevancy and fair trial. These are the two principles which have to be looked into, right? Yeah,
yes, my
you can
lady.
Continue.
Yes, my lady. My answer to this would be that the American Supreme Court has said that there are principles which are larger and more and which should take precedence over this, which is the deterrence effect that the exclusionary rule has on law enforcement, which in our submission is a very important consideration. That is, and also that this court has already accepted the exclusionary rule.
It's very simple.
Yes.
Just very simple proposition. Entry into the premises may not be in accordance with the convention or law, but what about the correctness of the evidence? If the evidence are found to be correct during the trial, they can be relevant, they can be well admissible also.
This is our central.
This is only
So your defense is only that forget about the nature of evidence, forget about its relevance,
Yes.
forget about everything else, but just look at the manner in which it is. So long and short of your argument is only this, that leave whether it is relevant, leave whether it points out to the guilt, clearly points out there is no other conclusion, but you must not, because it has been obtained in a way illegal so-called illegal manner, it should be ignored.
My lady, that is my central submission. But without prejudice to this, I will also.
So we should exclude the substantial justice and look at only that issue. That's what you are trying to say.
My lady, I would differ I would differ with my lady on what substantial justice would.
Yes,
Yeah,
that's
substantial.
what.
Yeah.
Please, you're free to differ. That's.
Yeah. I would differ with my lady on what substantial justice would entail. In my submission, what substantial justice would entail is also a compliance with constitutional values and the idea of
That
civil
you're
liberties.
right. That on a larger picture, you are right. It can't mean, but when we have such slippery grounds there is a judgment from the Indian courts, there are judgments from other courts, which say such evidence can be looked into. Why should we adopt just one abstract principle and say everything else goes out of the window? That's what you have to impress upon us.
My lady, I will again reiterate that this principle has already been accepted by this court. This is on the footnote on the last page of the proposition. And since we are a common law country, I would say that stare decisis is the soul of common law, and it should be followed. Now,
but that all right. Anyway, proceed.
Yes, proceed.
Please proceed.
And this has to be included with my submissions on voluntariness. Now, it is also my duty to inform this court that the exclusionary rule the law has evolved a bit, and there are certain exceptions that have been added. There are two broad exceptions. One is the good faith exception, which says that if the investigating officer conducts an illegality in good faith under the honest belief that he was not in fact breaking the law, then the evidence need not be discarded because it does not contribute to the deterrence. Now, as my colleague has already pointed out, the good faith part here is already put into great question. We see that the past conduct of the police officer is not exactly clean, and it does cast a reasonable shadow. Other than this, the fire claim is also very questionable. It seems like an ex post facto defense. For justifying the entry inside the embassy. Moreover, if your lordships look at the arrest memo on page 16 of the Moot proposition, this court will notice that the arrest note does not even contain the name of the accused, and that is a substantial procedural impropriety. There are also contradictions in what the confession says and what has been submitted by the state in their remand application. The confession nowhere says that, there is no part of the confession which says that, which admits guilt. And yet, in the remand application, the state has essentially submitted that guilt was admitted. Now, these are major discrepancies and cast a substantial doubt on the good faith on the good faith of the investigating officer. The second,
Suppose on the
Yes.
arrest memo, if the name of the accused is not mentioned, right? Whether it is fatal to the case of the investigating agency.
I would
If
not.
the other particulars are given correctly, if the FIR number, time, date and place of arrest, age, date of birth, other all particulars, they are correct, no dispute about it. Just non-mentioning of the name of the accused, proposed accused or petitioner in the present case, whether it will render entire proceedings null and void.
I would say that that alone would not be fatal to the case. But if one puts together this procedural improprieties and all the other procedural improprieties, including the inconsistency in the fire story, including the illegality. There's one more thing. In fact, an officer posted in a diplomatic enclave should know that you cannot force your way into an embassy. That is part of good faith. So none of these things alone cast a shadow on the good faith of the officer. Put together, it definitely does. That is our submission. Now, there is also a second exception to the exclusionary rule. It is my duty to point this out. The second exception says that if the evidence can be discovered independently of the illegality, or if the evidence would have inevitably been discovered independent of the illegality, then the evidence does not have to be excluded, because again it does not contribute to the deterrence effect. Applying this to the facts of this case, this exception squarely does not fall on this exception fairly does not apply to the CCTV footage part of the evidence, because the CCTV footage would never have been procured if not for the illegal search and seizure. However, let us come to the remains of the body, which were found in the parking lot of the mall. The question is whether this could have been inevitably discovered. Now, the US Supreme Court case which laid down this exception is a case called Nix versus Williams, and the relevant part begins from page 95 of the compendium. And what the Supreme Court has said is that in determining whether the evidence would have been discovered independently or inevitably, the standard that has to be applied is preponderance of evidence, and therefore, and in fact, I will briefly lay down the facts of this case. What happened here was that a girl disappeared. There was a suspect who was arrested. The illegality here was that he was entrapped into giving the location of the body. They said to him that we know the general vicinity of the body when they did not, and this induced.
Tell us one thing, was there not a probability that the body could have been discovered even otherwise later by somebody during patrolling or during some other exercise? It was not in the sea. Ultimately, it was on the land only, it was in the parking lot.
Yes, my lady, it may have been discovered.
Probability, ultimately we have to go on reasonable preponderance. So then how do you answer that?
Absolutely, Your Ladyship. This court has to go on preponderance of evidence. However, I will just illustrate what the US Supreme Court did here to do that exercise essentially. What they did was that there was in that case there was also a search party that was looking to the body for the body, and so what they did was to match the timings of where the search party had reached and when the entrapment took place. And so what my point is that there was considerable analysis on this question, and so the scrutiny, there has to be a rational basis to arrive at the conclusion that the body would have been in fact discovered inevitably. One cannot.
Could have been. We are saying not would have been. We are saying could have been at least.
Your
That
Lordship,
you are also admitting it could have been.
My lady, I am submitting that the standard should be would have been, because it is the inevitable discovery standard. That is my submission. And therefore, it is my submission that you cannot argue that the body may have been discovered, and therefore this exception should be applied. This will conclude my submissions. On the basis of these arguments, we seek quashing of the proceedings and release of the detained.
Thank you. Thank you.
Any question?
Judges, please note, Speaker 2 of Team URN 2220 has spoken for 17 minutes. Judges, the appellants have come to the end of their arguments. We seek your permission to allow the respondents to present their case.
Yes, please.
Speaker 1 of Team URN 2173 will present now.
Yes, please.
May it please the honorable bench, this is the counsel representing the respondent in the case
You
of
can,
case.
you can use the mic, please. There are young students
this-
wanting to hear you.
Is this audible, your ladyship?
Yes, after ask them also.
This is the counsel representing the respondent in the case of JJ Crook versus Emerald City Administration. I am counsel number 1 and I would be dealing with issue number 1 and issue number 2. My co-counsel would subsequently deal with issue number 3 and issue number 4. If with your kind permission, the counsel would like to start with issue number 1.
Yes, please.
Your ladyship, the first submission under counsel for the counsel under issue number 1 is simple. We don't believe that Mr. JJ Crook can be characterized as a diplomatic agent. The definition of a diplomatic agent under Article 1E of the Act, it says that a diplomatic agent can only be of two categories. A, either he is the head of the mission, or B, he is the member of the diplomatic staff of the mission. Member of diplomatic staff of the mission has been defined under Article 1D of the Act, which states that those people who have attained diplomatic rank and only those such persons shall be deemed to be diplomatic agents. My lords, two submissions regarding that. One, Mr. JJ Crook does not have any diplomatic rank. B, he is not a head of the mission, he is the security in charge of the head of the mission, which is to say that a function that has been carried out by the head of the mission, his function is to necessarily facilitate occurring of that function. Your Lordship, thereby we believe that another submission under the same argument, that if it is to be, it's an arguendo, if it is to be assumed that he is a diplomatic agent, the immunity would necessarily sustain from Article 31 of the Act. But the issue and the big hole in Article 31 would be then that Article 31(4) necessarily states that it does not exempt you from the jurisdiction of the sending state. Thereby, every diplomatic agent does not get criminal jurisdiction, criminal immunity internationally. It is only for that particular nation. Now, if we were to assume that Mr. JJ Crook is a diplomatic agent, the issue with that would be that his jurisdiction for the current trial of the case would be foreign country. We don't believe that that court has any jurisdiction to try the current case, and thereby we would be going on the definition that he's a member of technical and administrative staff of the mission. Much obliged, Your Ladyship. The second submission under issue 1 is that once it's established that the definition is under Article 1F, the only immunity that can be attained by Mr. JJ Crook stems from Article 38(2). Article 38(2) inherently states that members of the mission who are also nationals of the receiving state shall enjoy privileges and immunity admitted only to the extent of the receiving state. Your Lordship, on this, Dr. Wagner has also produced commentary on the fact that the power of the receiving state and whether and how such privileges and immunities are to be granted, the function and the power necessarily states in the receiving state, and sending state has no control over such power. Secondarily, in the same commentary, he has also commented that if the receiving state is of the opinion that the national shall not receive any immunity, then the receiving state has all the powers to deny immunity for all the acts committed. Thereby, Your Ladyship, if Your Ladyship is satisfied, may I proceed with the third submission under issue 1?
On the first submission, you've just touched it. You haven't told us, you haven't dealt with your opponent's plea that they have labored a lot on showing why he will fall within 1E. You just said it and left it. That's not the way you argue in court.
Apologies, Your Ladyship. The
You
purpose...
have to at least meet their argument. They have taken great pains to argue why it falls within 1E.
Indeed, Your Ladyship.
They've also tried to explain that it is only drivers and mechanics. What do you have to say if he was the head of the security? Why would he not fall within 1E?
Your
You
Ladyship,
just touched it and just left it for us to decipher.
the rationale behind
Then we'll
their...
do it.
Apologies, Your Ladyship. The rationale behind their argument was that he is a representative of the foreign country and thereby he should be deemed to be declared a diplomatic agent.
I think you were too engrossed reading your brief.
Apo-
That's not the way you work in court.
Your Ladyship, because their argument, diplomatic agents are necessarily representation of the sovereign, we believe that every diplomatic agent should be seen as a representative of the sovereign, that is on the sending state. We don't believe that JJ Crook commits any function that would be seen as a representation of the sending state. For example, Your Ladyship, Article 3 specifies that what are the functions of a diplomatic mission. Article 3 and under Article 3, the categories that have been specified, that is the purpose and the functions that every diplomatic agent necessarily has to do. Now, Mr. J.J. Crook does not do any function which is laid down under Article 3 of the Act itself, which means that if any argument of him being a diplomatic agent, his functions would necessarily also have to have the same resemblance. We don't believe that any of the functions carried out by the security in charge, even if we agree to that, have any resemblance of representation of a sovereign. If
You mean to say he cannot claim the sovereign immunity?
I'm saying he cannot claim criminal immunity in the current case. Your ladyship, secondarily, the argument regarding that why he cannot claim criminal immunity stems from ILC Handbook 1957. The handbook explicitly has not given nationals of the receiving state immunity for particular reasons. May I read page number 24 of our compendium, your ladyship?
Yes, please.
Page number 24, paragraph 13. It says, to accord immunity from criminal jurisdiction to such a diplomatic agent would place him in a unique position. Ordinary diplomatic agents, though immune from criminal jurisdiction in the receiving state, were nonetheless subject to the jurisdiction of the sending state. But a diplomatic agent who was a national of the receiving state and enjoyed immunity therein could commit murder with impunity, since he would not be subject to criminal jurisdiction of the sending state either. Your ladyship, this is inherently our second submission within issue 1. At any point of time when it is argued that he would have criminal immunity from such acts, then he would be one person who would be allowed to commit crimes in this country and get away without any court in the world having jurisdiction to try the particular case. Same argument aligns with principle of Article 31, subclause 4. This argument is on the basis that this creates a lacuna in international law for an individual if he is given immunity from both sending and the receiving state, which is to say that any crime committed by him, and your ladyship, in the same handbook in year 1957, it has been also laid down under paragraph 16 that crimes do not necessarily have to be of grievous nature always. For example, an act of criminal negligence that could be easily committed by a head of security in charge, that act would also be then not be seen as a criminal violation of the receiving state. Which is to say that Mr. J.J. Crook would be then treated as a person who is above the law of both the countries. That legal position would then create various problems in the current court, your ladyship. Your ladyship, if I may also argue from the same handbook, under paragraph 26, it has been laid down that this staff, there is also chances of turning disloyal to the original state that he belongs to. At that point, the original state, which is the receiving state, should not feel helpless in the particular case, which is to say that if the national employed in the embassy now acts against the interest of the receiving state would not have any ground to try that particular person in that country. At that point of time, your ladyship, it is laid down under the same handbook that in ideal situations and in most circumstances, criminal immunity shall not be given to nationals which are belonging from the receiving state. If I may proceed with the third submission, your ladyship, then. Your ladyship, the third submission is regarding the value of international customary law. International customary law is recognized under Article 38 of Statute of International Court of Justice, which is to say that international customary law would be seen as precedents in some courts as secondary form of law. Your ladyship, on that ground, we would argue four different conventions under which specifically for the same reasons, criminal immunity has not been granted to such nationals. First convention is Vienna Convention on Diplomatic Relations, Article 37. Article 37, the immunity is explicitly not given to national in all four subclauses, which is to say that every clause under Article 37 has an exception within that it would not be granted to the nationals of the receiving state. The second submission is that Diplomatic Privileges Act, which is the law of United Kingdom. Law of United Kingdom also explicitly states down that no amount of criminal immunity shall be given to any of the nationals working in the particular embassy or working for any foreign nationals. And lastly, your ladyship, if I may also read the position of United States in terms of granting criminal immunity to the nationals working in embassy. Your ladyship, it's on page number 27 of our compendium. If I may read, it states...
Yes,
it states the general rules set forth assume that the staff of the diplomatic mission are nationals of the sending country or some third country. The United States, as a matter of policy, does not normally accept as diplomatic agents its own nationals, legal permanent residents of United States, or others who are permanent residents in the United States. The family members of diplomatic agents enjoy no privileges or immunities if they are nationals of the United States. Members of administrative and technical staff and members of service staff enjoy no privileges and immunities if they are US nationals, legal permanent residents, or foreign nationals permanently residing in United States. Your Ladyship, the same principle is essentially followed in the country of India as well. India also does not grant criminal immunity to the nationals working in the embassies, which is to say, Your Ladyship, it is a very well followed norm of law that these situations should not arise when one person inherently would be above the jurisdiction of any country in the world. Your Ladyship, with that,
we go on that broader proposition that because it is their own national, he should not be given immunity. As you say that in India also this is the position. Even if he was working on a more senior post, like a special post integrated with the diplomatic function, even then he should not be granted according to you.
Your Ladyship,
we are only wanting to know what your proposition is.
Our proposition is that till the point of time he either categorizes as a person holding a diplomatic rank or he is categorized as a person being head of a mission.
Alright, so then you say he would be excluded.
Yes, Your Ladyship. The moment it would be proven that J.J. Crook holds diplomacy rank, we would be assuming that he now holds criminal immunity.
Alright, please proceed.
Your Ladyship, then if the bench is satisfied, the council seeks permission to start issue number 2.
Yes, please do. Your time is running.
Your Ladyship, under issue number 2, we will have 3 submissions. The first submissions will be that the principle of inviolability is not an absolute principle, but rather balanced out against other articles present in the VCDR itself and other international law, which is to say that one article does not overpower or is superior to any other article present in the Vienna Convention of Diplomatic Relations. The first article, as has been rightly pointed out by the bench in their speeches, that Article 22(2) has also put down a special duty on the receiving state to act in the interest of protecting the premises. Article 41(3) of VCDR also puts a special duty cast upon the people working for the receiving, working as nationals of the receiving state to adhere to the law. Thirdly, Article 25 of Articles of State Responsibility also enshrines the doctrine of necessity, which is to say that in a situation where necessity and the only consequence and the only action that can be taken is the action that is taken, then the action and a violation of international law would be justified. Your Ladyship, secondarily, and in this we have 2 arguendos. One, the claim of diplomatic inviolability is a claim that had to be raised by Faroe Embassy. We don't believe that even if Mr. J.J. Crook can prove that the premises are inviolable, there does not exist any right for him to claim any damages on the same argument. Which is to say that if premises have been violated, the raising of violation had to be done by the Faroe country and the sovereign of Faroe.
But ultimately he is going to be penalized, so why can't he raise the defense? That we don't
Your Ladyship, because the right of inviolability exists with the state, we don't believe that any damages to the right can be sustained by the other person. Your Ladyship, secondarily...
It cannot be claimed at individual level.
No, Your Lordship. The first argument under inviolability would be that the right exists of the sovereign, and VCDR creates rights...
Where do you get it?
Your Lordship, it's stated in the Article 22, and Your Lordship on this...
Let's read Article 22 again. Yes.
The premises of the mission shall be inviolable. The agents of the receiving state may not enter them except with the consent of the head of the mission. So it does not state that at any point of time when such a violation has occurred, that the right can be created in an individual.
Where does it bar it also?
Your Ladyship,
that an individual cannot raise his right.
Your Ladyship, that has been settled in the Dorf case in 1973 by the Supreme...
Then you have to take us to that instead of taking us to the article which doesn't support you.
Indeed, Your Ladyship. The Dorf case has been attached to our compendium. The brief facts of this case were that a person not having diplomatic immunity was arrested on diplomatic premises. The premises were declared to be inviolable, but the arrest was held to be legal on the ground that violation of principle of inviolability is a claim that had to be addressed diplomatically between the 2 countries and could have no bearing upon the legality of the arrest. Your Ladyship, if I may read just one particular paragraph of the Dorf case.
Yes, please do.
Even if the arrest was a technical breach of the convention, the acts of the police were justifiable because the attaché has misused his diplomatic status and inviolability of premises by hiding a person wanted by the police. Any violation of the convention would have to be dealt with on a diplomatic level between 2 states involved and could have no bearing upon the legality of such arrest. the magistrate court ordered that Mr. Dove had to be kept in custody. The same order of magistrate was held in the Supreme Court, stating the same facts, that the principle of inviolability has to be settled between the two states and not between an individual and a state. Your Ladyship, if I may continue on this argument, the principle that they're arguing again on the immunity and the inviolability, the principle only grants immunity to the extent necessary, which is to say that if Mr. J.J. Crook has murdered someone, that would not be covered under the theory of functional necessity. Theory of functional necessity would be, let's say, similar to the theory of private defense, which is to say that you're only allowed to commit such acts to the extent that are necessarily required, which is to say that the murder of Miss Penny Watts is not a necessary action that they had to commit to in order to validate that immunity or to raise the principle of inviolability. Lastly, Your Ladyship, their argument that actions cannot be justified ex post facto in violation of this case. Your Ladyship, this issue has also been dealt with on page 50, if I may read so, on our compendium. Your Ladyship, if I may just read.
Yes, please
So,
read.
In the last resort, a receiving state which is sufficiently armed with evidence of abuse which it will find will probably take the risk of breach of Article 22 of the Convention if it believes that it is essential for the security at risk. The ambassador, Mr. Himakat Suleiman, refused permission for the search. The forcible entry into Iraqi embassy could be justified ex post facto because Iraqi embassy clearly violated the provisions of Article 41(3) not to use the premises in any manner incompatible with the functions of the mission. It is obvious that entry into premises of diplomatic emergency mission could only be justified in an extreme case of abuse. Which is to say, Your Ladyship, now that we have proof and evidence of committing of an act, the action of entering into premises can be justified ex post facto. Which is to say that the principle that they're arguing on, that the evidence collected inherently is wrong, we don't believe that that principle stands in according to the international laws.
You understood your point.
Much obliged, Your Ladyship. Your Ladyship, the last submission under issue 2 would be that the principle of inviolability is not an absolute right and there exist general exceptions already written down. The first exception written down by Mr. Francis Wharton in his commentary is of the fact that any embassy or any staff of the embassy, when they commit acts of outrageous character, which is to say that they are not only violating the immunity that have been granting to them, they are also violating the duty that has been established against them under Article 41(3) of the Act. Second exception, which is written down again by Mr. Caleb Cushing, who is the former Attorney General of the United States, he has also laid down that if it's in the interest of public security or if it's in the interest of public safety, some persons can be arrested on the premises of the of the embassy, sustaining on the fact that the arrest was subsequently proven to be legal. That is to say, Your Lordship, it's inevitably proven throughout various provisions, and it's also against the balance of various sections in the Act that Article 22 is not an absolute but rather a qualified right. We believe that the actions of appellant have not qualified to that extent, and we believe on that ground the principle of inviolability shall not stand. With that, we would like to end our submission. It was an honor arguing before the bench.
Thank you so much.
Judges, please note, Speaker A of Team URN 2173 has spoken for 18 minutes. Speaker B of Team URN 2173 will speak now.
Please do.
The advocate is not given a chance to speak.
I know I was going to say that.
If I'm audible to your lordships. My lords, I'll be dealing with issue number 3 and issue number 4 respectively. And before I begin with my submissions, a prima facie rebuttal to the principles laid down by my learned friend on the other side, wherein they state that the reason why they want this honorable court to mandate the exclusionary rule is to provide the balance between civil liberties and public policy. We state that possibility of upholding civil liberties exists in the current status quo, which is the rule of relevancy, wherein the discretion through various judgments that I'll be taking my lordships through, wherein the discretion is given to the magistrate considering the issue, and in terms of the facts of the case, if grave unfairness is being caused to the accused, in that situation, evidence may be discarded. Therefore, the angle of civil liberties is not a burden on this court to allow for an exclusionary rule being mandated wherein any and all sorts of evidence gathered illegally should be prima facie excluded from consideration by the honorable court, wherein the balance of convenience would lie against them and therein public policy would be defeated. Keeping that premise in mind, I would like to take my lordships through page number 84 and 85 of the compendium, which deals with the case of Barinder Kumar Ghose. And my lordships, the submission is quite simple and clear in terms of the relevancy test being the test of admissibility. And with my lord's prior permission, I would like to quote a particular line. For without in any way countenancing the disregard of the provisions prescribed by the code, I hold that what would otherwise be relevant does not become irrelevant because it was discovered in the course of a search in those provisions whose the code was discarded. And my lords, the reason why the civil liberties aspect is also covered, if my lords could go to para 64 of the same page, wherein the lordship talks about how the evidence so procured is used for twin purposes. The first purpose is to proving to the truth the contents of that particular document, and the second is for the purpose of whether or not those contents are relevant for the case at hand. Therefore, if exclusionary rule is mandated, neither of the twin provisions could be done because the court would simply say that it was an illegal search that would discard that document. Therefore, now the contents of proving to the truth and whether or not the accusation on the accused is being proved by the document so relied on needs to be admitted for the court to make a judicial decision. At that point of time, the rule of exclusion.
So you're saying we should go in the opposite direction. First we should see whether it proves his guilt and then decide whether...
No, my lordships. No, my lord. I am stating that...
That's what we thought.
No, my lords. I am stating that the evidence being relevant should be admitted, and then the court should take into question whether or not the evidence is proving the guilt of the accused, whether or not it's causing him any sort of unfairness, and whether or not that vitiates the proceedings. It cannot be taken at a prima facie level that just because it was illegally gathered, we will not look into what the evidence states and what is the accusation against the accused and what it further proves. If my lords are satisfied, then I would like to deal with the other aspect, which in this case has already been partly dealt with my co-counsel, is the fact that in this case, by admitting the evidence relied on by the prosecution, no unfairness has been caused to the accused. The maximum the accused made defense is that there has been an illegality in terms of the breach of the convention, which again, as stated by my co-counsel, is the illegality imputed to the state. That is, the state of Ferva may claim that the illegality has resulted in some sort of mandatory doctrine being violated by the Republic of Crete. However, that illegality is not imputed to J.J. Crook. Therefore, any sort of unfairness that might be imputed to him should have been argued on the side by stating that there was no judicial application of bind by the magistrate, which we will come to in terms of the reasoned order given by the magistrate, that in terms of keeping with the dictum of the Supreme Court in Gautam Navlakha and others decisions, the magistrate has applied his judicial mind. Therefore, there exists no cause for this court to interfere with that order of remand, because in the end, your lordships, our relief from this court is to dismiss the writ petitions. We are not at the stage of trial. Therefore, any sort of contradictions or any sort of probative value between the evidences and between the statements this is not the stage at which the court shall look into it for the current purposes. If my lords are satisfied, I would like to move on to my further arguments.
One thing is there, if the petitioner can claim the diplomatic immunity, then there is no need to look into the relevancy and admissibility of the collected evidence. If I am immune for all the purposes?
Yes, my lords, absolutely. However, in this case, if the petitioner had been the ambassador of Ferva, then all the consequential arguments would have been redundant. However, since at this case, the fact of whether or not the person is entitled to diplomatic immunity is itself contested, therefore, at this point of time, even before going into the relevance of the evidence, that fact needs to be decided by the court. And that is again a matter of trial, because this is not a court of facts, but this is a court of law. Therefore, at that point of time, again, our relief again being that dismiss the writ petition and allow the investigation to go on for the remand application. If my lords are satisfied, I would like to, if I may proceed. My lords, again, regarding Article 24 and inviolability as stated by my learned co-counsels, they state that Article 24 confers an absolute inviolability of the documental archives. However, there has been a case in the case of Bancolt, wherein Lords, I can't remember the justice's name. However, the honorable bench stated that if the documents find their way into the hands of a person, no matter by virtue of inviolability, they are prima facie admissible. Therefore, there has been an exception granted out for Article 24 within the international law jurisprudence with regards to inviolability of the premises. If my lords are satisfied with that argument, I would like to make my next submission, which for that I would like to refer my lords to page number 191 of the compendium, which is the classical case of Kuruma versus R, and which again deals with the fact, and this judgment also deals with the doubt or the tension that the appellant has with regards to civil liberties. Because Kuruma versus R clearly states that the magistrate or the person dealing with the evidence has the ability and has the right to exclude it on the basis of unfairness. In this situation, we submit before this honorable bench that no unfairness has either been pleaded by the opposite party, nor has it been even prima facie proved that certain sort of unfairness has been caused. The only cause of unfairness or illegality on the other side is that Article 22 or 24 have been violated. In such a situation, since no unfairness is imputed to the magistrate or to the accused, there is no reason for this honorable court to interfere with the order of remand. If my lords are satisfied, again, I would like to read a paragraph from the memorial because this case is relevant for the case at hand. If my lords could have paragraph number 41 of the compendium, which is the case of Emperor versus Allahabad Khan. Of the memorial, my lord, sorry, I apologize. Paragraph 41 of the memorial. And if I may quote with my lord's prior permission, the facts are similar to the current case, wherein a search was conducted without obtaining the requisite warrant. It was held that the conviction of the owner and of the house under Section 3 of the United Provinces Excise Act was not rendered invalid by the fact that no warrant had been issued for the search, although it was presumably the intention of the legislature that in a case under Section 63, where it was necessary to search a house, a search warrant should be obtained beforehand. Therefore, yes, my lords.
No, it was necessary. That's what you read that line.
Yes, my lords. The
Here
judgment.
nobody held it was necessary.
My lords.
Your own wisdom or whatever you thought on your own that it is necessary.
No, my lords. If I may make a submission, the argument is in response to the mandatory nature of the Vienna Convention argued by the appellants.
Yes.
If that argument is accepted, and my contention to that argument is that even worst case, if it is assumed to be mandatory, there is common law jurisprudence that states even in such a situation, a search if warranted, and that warrantness of the search is to be judged by the relevancy of that evidence. In such a situation, A, evidence shall be admissible, and secondarily, then the trial may proceed on the weight of such evidence. If my lords are satisfied with that issue, I would like to move on to the next submission. My lords, the next submission is resting on the case of Al-Malkis versus Rees. And herein our submission rests on the fact that in that case, the Lord Sumpton gave the judgment, and he stated certain situations wherein one of the examples he gave was that a US diplomat was sued for an action of divorce by his wife in a country where he was an ambassador. Till the time he was enjoying such immunity, the court did not proceed. But at the moment he left that country, the court proceeded stating that that immunity no longer exists. Therefore, their entire contention is that J.J. Crook has functional immunity. The investigation by D.I. Bain started after the ambassador had left the country. Therefore, any sort of functional immunity that he might have claimed defense for no longer exists in relation to the ambassador. Therefore, he is not entitled to the immunity in the first place. In such a situation, we feel that
Just one second, I don't know, maybe we are factually not clear.
Yes,
he was the head of the security or he was only his bodyguard?
My
Because
lords,
you said the moment the ambassador left,
yes, my lord.
he was not only security guard because the other side has argued that he was the head of the security.
Absolutely agreed, my
So
lords.
if he was the head of the security, how is his functional going? Even if the ambassador goes, he is the head of he remains there.
Absolutely, my lords.
So
However,
factually, what you're saying doesn't seem to be correct unless they are wrong.
my lords, my submission is that their immunity is based on the factum of J.J. Crook protecting the ambassador from penny wards. At a point of time where that factum has ceased to exist, wherein he is no longer entitled or he is no longer required to protect the body of that individual, at that point he is liable
He
to
is
be
the head
proceeded
of the
against.
security, he is to protect the whole mission.
However, in such a situation also, my lords, the entitlement of J.J. Crook is limited to the function that he is doing. Yeah.
One
Alright.
question.
Yes,
one
my lords.
question. When the crime was committed, at that time, was he acting as a head of security or not?
Yes, my
The
lords.
ambassador was there, so how can you now claim immunity is not available because the act was done at the time when the ambassador was there?
Yes, my lord.
So
My lords,
subsequently, you can't say that situation has now changed.
my submission is...
How the immunity can vanish merely on the
With the-
departure of the ambassador?
My lords, twofold submission. Again, the first submission is again something that I've already stated before, my lords, that the factum of immunity is also in question. Therefore, that needs to be
So
decided.
that's a different aspect.
Second, my
We
lords,
were
my-
only on the factual this thing when you said,
Yes, my
made
lords.
this submission, we were a little intrigued, so
Yes,
we
my
asked
lords.
you.
Yes, my lords. The second submission on that ground is that the functional immunity to be claimed by any sort of
know.
the pleadings by the appellant any sort of functional immunity that they've not claimed to the entirety of the premises in their own submissions. They've claimed it to the
No,
protection
even then
of
it
the
will
bodyguard.
relate to the date of, or the
Yes, my lord.
date of the cause of action.
Yes, then I will
The
relate that to the necessity required for us to
That's
go
a
against.
different thing,
Yes,
but
my
your
lords.
proposition, this proposition,
My lords, it's a
somehow-
secondary proposition to which I'll be qualifying with the aspect of necessity.
alright.
If my lords are satisfied, then I'll directly move on to that aspect. If my lords could go to page number 126 of the compendium, which basically deals again with common law jurisprudence regarding the test of proportionality, regarding relevance. So herein, and again I quote with the prior permission of my lords, wherein in R versus Shahid, it was ultimately held that whether exclusion of the evidence is in the circumstances of a response which is proportionate to the breach which has occurred of the right in question. Therefore, the right in question that is being claimed by the appellant is that they were entitled to certain immunity, and therefore the consequential searches were in breach. However, at that point of time, it needs to be balanced with the test of relevancy, wherein the evidence so collected, whether or not it outrightly outweighs those rights being claimed by the appellant. In this situation, the evidence so collected is the CCTV footage, is the accused being seen wiping off the table, which again I'll relate back to ILC reports, wherein it is expressly given, Article 24 read with Article 29, that wherein an authority of a receiving state sees a crime being committed, he has the authority to prevent that crime. The formation or the magistrate prima facie has made a view that the accused is also guilty of destruction of evidence, and it was the DI Bain who looked at him cleaning that furniture. Therefore, under international law jurisprudence, the DI Bain is at that point of time entitled to momentarily arrest him and to prevent him from committing that further offense. Therefore, in such a situation, even if immunity is granted by my lordships to J.J. Crook, even then the arrest may not be deemed illegal, and then the consequential evidence may not be deemed illegal. If my lords are satisfied with this point, I would like to move on to issue number 4, which is the consequential confession and the recovery made thereof. My lords, if my lords could have page number 80 of the compendium, which effectively deals with the aspect of confessions, and my lords accept the Indian law jurisprudence that has developed by virtue of Selvi versus State of Karnataka. However, we would like to draw a distinction. The distinction being that here the factum of consent again is also debated, because the police investigation report states that the accused voluntarily accompanied the police officer to the police police authority. However, on the other hand, the other side claims that he was not, like, for example, in criminal law jurisprudence by the appellant, they're drawing that custody leads to an assumption of consent not being free. At such a situation, even then, if my lords could have page 80 of the compendium, and wherein the law in the United States has been summed up, and therein also I would also like to bring to the notice of this honorable court that the Weeks versus Vermont rule in the United States is also not followed by all the states within that country. The various supreme courts of that states in some states have rejected the Weeks versus Vermont rule, stating that it only applies to federal prosecution and does not apply to state prosecution, wherein they said that the test is of relevancy. Therefore, the exclusionary rule, which is by far the unique product of the United States of America, is not in itself consistent within the United States of America. And with the prior permission of my lords, I would like to quote from page number 81 of the compendium, wherein the states differing from the McNabb rule, which basically stated that any sort of confession, if deemed under custody, shall be inadmissible because it's assumed to be involuntary. The states have differentiated from the McNabb rule and continue to follow that the mere delay in arraignment or mere delay in confession, it was not clear whether illegal detention of itself is a bar on the admissibility of such confession. And some federal courts wrote in a rule of reason into the McNabb rule only to exclude a confession where the accused has not been properly taken before a committing magistrate. Therefore, they've also read into the McNabb rule certain exceptions that if you're, for example, if we take the law in India, if you're not produced before a magistrate within 24 hours, then the McNabb rule might apply, and then we might say that the confession so granted is involuntary and therefore inadmissible. However, in this case, this particular exception does not apply because within 24 hours, the accused was presented before the magistrate for an order of remand. If my lords are then satisfied, I would like to move on to the aspect of application of judicial mind by the magistrate. My lords, the magistrate in their order, has stated that by virtue of taking into account the relevancy of such admission, there is a case for remand being made out against the accused. Apologies for the delay, my lords. My lords, if I could just take my lords to the relevant paras. Para number 8 of the remand order. It is submitted that Mr. J.J. Crook was seen destroying evidence by cleaning the furniture in the ambassador's room with a wet wipe. The cloth has since been seized. Apart from the wet wipe, the police have seized CCTV footage of the incident. The statement of Ms. Washra has been recorded. And the magistrate has also taken into account the objections raised by the counsel of J.J. Crook as well. Therefore, the magistrate has applied his mind to both the parties and then made an order of remand. Such a prima facie order cannot be said to be non-application of judicial mind. And in such a situation, this court should refrain itself from interfering with such orders on basis of pedantic nature of such orders, stating that certain words were not used in a particular manner. In such a situation, my lords, I would like to take my lords directly to my last submission, which is the confession of J.J. Crook. And my lords, my submission is brief in this situation. Regarding relying on the locus classics of Pulukuri Kottayam and the recent judgment of the Supreme Court in Ramanand versus State of UP, 3 things need to be imputed to the confession maker to impute the discovery to him. First is knowledge, second is authorship, and third is concealment. If my lords could have a preliminary glance at the confession statement of Mr. J.J. Crook, and the part which is admissible, is essentially states, after that something unspeakable happened. One of the other bodyguards told me that he was going to burn in the Emerald City parking lot. In such a situation, relying on Dudnath Pandey, relying on Ramanand versus State of UP and Pulikuri Kottayam, the fact that the accused states, I have knowledge of where the weapon is concealed, would not impute that discovery to him. There needs to be authorship and there needs to be concealment as well. And in no such situation is that concealment being proven. Therefore, the recovery is imputable to that individual, and at such point of time, it becomes abundantly clear that the remand of that accused is required for further investigation, and the order of the judicial magistrate is made in judicious wisdom, and in such a situation, the writ petition shall be dismissed. It was a pleasure. I end my submissions if my lordships have any queries.
Thank you.
It was a pleasure arguing before this court. Much obliged, my lords.
Judges, please note, Speaker B of Team URN 2173 has spoken for 18 minutes. The respondents have finished their arguments. Judges, the appellants have reserved 5 minutes for rebuttal. We seek your permission to allow Speaker 1 of Team URN
All right. You want to rebut?
2220.
Please come. Please come.
The right to rebut. The right to
Much
rebut
obliged.
is a fundamental right.
Your ladyship and your lordship, with regards to a very pertinent observation that was made as to when does his immunity vanish, there is a very important clause that was conveniently left out under the convention itself, that is in Article 43 of the convention, that talks about the function of a diplomatic agent comes to, the function of a diplomatic agent comes to an end, inter alia, when there is a notification by the sending state itself or a notification by the receiving state to the sending state. In the present case, none of this has happened, so the functions of the diplomatic agent has effectively never ceased to take effect in the case. Addressing the claims of immunity that were given, there was not a single material to state that Mr. Crook could not fall into the category. It was merely rebuttal on the assumption that Mr. Crook would not fall under the category of a diplomatic agent. There was, if we read, a point was raised that under the sovereign character of Mr. Crook, our argument don't go on the sovereign character at all. Essentially, when the basis of the Vienna Convention is on the functional necessity theory. You don't give immunity merely because he's a representative. You give immunity because the functions he does for the mission are important to be confidential and away from any interference by the state in the international affairs of things. And another point was raised that jurisdiction of the sending state will not be applicable and jurisdiction of the receiving state will not be applicable. This ground in itself would not provide jurisdiction to a state which does not have the power to act upon the jurisdiction. Merely because the state does not have jurisdiction, it cannot read in jurisdiction just because no other state can exercise jurisdiction on that aspect as well. And your ladyship, it was repeatedly raised that Mr. Crook would be above the law. This is in clear violation, or rather completely in contravention to the purpose behind the act, the convention as well. The convention says in the preamble itself that immunities are not to provide protection, but rather to ensure smooth functioning of the business. And in this regard, it cannot be said that merely because the immunities are given, the accused will be above the law. That is essentially a small point, that a drawback that is to be taken in the larger scheme of things of international relations between the country. And ladyship, with regards to certain statements made by the US Supreme Court, the US Supreme Court is not an authority to interpret the provisions of Vienna Convention on Diplomatic Relations. And I will highlight this fact with a judgment which is deemed to be a landmark judgment on diplomatic law, that is by the International Court of Justice in the Tehran hostage case. Briefly addressing the facts, certain Iranian militants had entered the American embassy and captured the diplomatic agents. No action was taken for few days because their entrance was blocked for them. They could not gain entrance into the premises itself. Thereafter, in the convention, in the judgment of the International Court of Justice, the verdict which is at the last page of your compendium, it expressly states that Vienna Convention on Diplomatic Relations is a self-contained code. You cannot read in, especially if another act provides, as it was stated, Article 41, or under the Statute of International Court of Justice casts a duty to interfere. Those things cannot be read into a Vienna Convention, which is in fact a self-contained code. You cannot read in singular statements from people given under a commentary when it is against the treaty itself. And addressing the points regarding inviolability, it is submitted that the inviolability is indeed absolute. The commentary that was stated does not see what Article 22 in unequivocal terms especially says. The premises may be inviolable at all times. And your ladyship, in the case of the representative character that the ambassador, the agent did not raise his claim that he should have raised, your ladyship, the ambassador is a representative of the state itself. Now, if a case has to be made or there's any dispute, you wouldn't call upon the state of fervor to come and file a case. The ambassador in the representative character will file a case. In that regard, Mr. Crook is in a representative character of the state itself, and if he's represented in a proceeding, he will be represented in due proceedings regarding
That may be a little far-fetched, but
your ladyship,
that he's a representative of the state, but
his functions represent the functions of the state under the convention itself.
all right, anyway, that's a little far-fetched argument, but
Yes, your ladyship, the far-fetched aspect would be the consent, regarding the consent revoked. The ambassador has the authority, but we cannot assume that merely the ambassador would be a representative character. Let's say there is another...
that is well taken, that is taken.
Yes, your ladyship. And your ladyship, the commentaries that were cited, they cannot be about the treaty. They cannot say something which I seek an extension of 1 minute to redress.
All right, 1 minute.
1 minute.
Yes, your much obliged, your ladyship. Your ladyship, in that regard, they had submitted that there is no hardship that was suffered. Your ladyship, Mr. Crook has been in custody for 15 days, and this custody is in blatant violation of the Vienna Convention. They may argue that there is no immunity and it's just a procedural impropriety, but such an investigation, it's ultra vires the authority itself. They cannot do an investigation in this regard, and especially when they address the point that mission would, as the ambassador had left, there was nothing to do with the mission itself. That does not take place as it was laid in Article 41. The mission does not come to an end merely because an ambassador has left the case. And if we apply the exclusionary rule that was laid down, the exclusionary rule is applied. They have stated that the states have different laws, whereas the federal law is different. It cannot be said that way because the exclusionary rule applies not just to federal proceedings, but to all proceedings in itself.
Thank you.
Much obliged, your ladyship. It was an honor.
We have now come to the end of the final round of the 20th KK Luthra Memorial Moot Court 2024. Thank you, judges. We hope you had a pleasurable experience with us. We look forward to hosting you again in the future. On behalf of the entire KK Luthra family and Campus Law Center, we extend our heartiest gratitude to you for giving us your valuable time. Thank you so much once again.
Thank you. It was our pleasure. Now we need to give the mark sheet. अभी 5 minutes.
We request everyone to please be seated. In about 20 minutes, we'll start the prize distribution ceremony.
How they do it. All right, we'll do that. Yeah. Because we'll be able to, we'll be able to consult. Yeah. I've got my reference. सबको पता चलेगा we can do it here also. I mean, it's okay. पता लग जाएगा ना आपको हाँ पता लग जाएगा
Good evening, everyone. A very warm welcome to this August valedictory session of the 20th KK Luthra Memorial Moot Court. I would like to extend a special welcome to our chief guest, Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. I would also like to welcome Honorable Ms. Justice Rekha Palli, Justice Neena Krishna Bansal, and Honorable Dr. Justice Sudhir Kumar Jain of the Delhi High Court, Professor Dr. Alka Chawla, Professor in Charge, Campus Law Center, Dr. Suman Yadav, Faculty Convener, Moot Court Society, respected faculty members, and other dignitaries present amongst us, and most importantly, our participants, whose hard work, dedication, and perseverance have led them to this momentous occasion, whose achievements we are all here to celebrate. I would like to invite upon the stage Professor Dr. Alka Chawla, Professor in Charge, Campus Law Center, to give her welcome remarks.
Thank you, Khyati. Good evening, everyone. We always wait for this moment to arrive. Annually, 3 days of, I think, it's Campus Law Center mein marriage ka mahol. So it's like a vidai now, but with all happiness. So, sir, we are very happy to have our chief guest here, Honorable Mr. Justice Vikram Nath. He was the former, he is now the Supreme Court judge. He was formerly Chief Justice of Gujarat High Court. He is the first Chief Justice of a High Court in India to live stream the proceedings during COVID pandemic. He is the 4th generation of law people. So I think the law is running into genes and the blood of the entire Nath family. A big applaud for him. He's taken out He has taken out time for our Campus Law Center and for this moot. Sir, we've had 3 days of mooting, and you can see all the participants here with smiles and a little bit of nervousness because prize distribution has to take place. They still do not know who has won and who has lost. And just before you arrived, we had the final round between 2 teams. And one thing which I want to say is that all the 3 judges are the alumni of Campus Law Center. A big applaud for them. I have known Honorable Justice Rekha Palli from her judgments and from the way she's fought for women's rights and for Air Force officers. But one thing, what I came to know was from my own son. You know, he started practice and he's the first generation lawyer, and he came back home and he said, Mama, there's one Justice Rekha Palli. She is so encouraging. You know, no judge has ever given me so much of a respect, affection, and a listening and motivation and inspiration as hers. And that's how I started knowing her. Thank you. No, thank you so much. And that is how she's become a family friend. So, and of course, you've seen her throughout. Though she was asking questions, she always says, hard work, politeness, but with firmness. Her face contours are very firm, but she's very polite, and she's very affectionate and very motivating. A big applaud for her. We have Honorable Miss Justice Neena Bansal. Krishna, बहुत लंबा नाम है इनका. हमेशा बोलते हैं Neena Krishna Bansal. She's also an alumni. She's a trained mediator, and I think when you listen to her musical voice, you can make out that in a very nice, smooth, musical voice, she can mediate. All the even fighting litigants, they start looking at her and listening to her, and they come to some kind of सुलह समझाई हो ही जाती है ना मैम? So she's been training. She's a trained mediator herself and master trainer with Mediation Conciliation Project Committee. She was also the director of the Delhi Judicial Academy. And then we have somebody who's very, very close to our hearts. Why I will tell you, one, because he's a CLC alumni, Honorable Justice Sudhir Kumar Jain. Secondly, he is a unique combination of bar and bench and teaching. He has taught in Campus Law Center. And just now one of the students, one alumni came here and said, हम सर आपको तंग करते थे. ऐसे तंग करना तो students का काम है. लेकिन इतने प्यार से और smoothly जवाब देना वो teachers का काम है. And that is what personifies Justice Sudhir. It's been lovely knowing you all this time, Sudhir. So happy to have the entire alumni bench here. We are very happy and honored, and in fact, we feel indebted to the Luthra family. Three children. Meera Didi, Geeta, Siddharth, all three of them with their spouses. They have always, we've come to the 20th edition now. A big applaud for them. And we would want, in fact, more and more such alumni to join in and make Campus Law Center a beautiful place and more competitive. All our thanks and welcome to the entire family and friends of Luthra family. Every year we keep seeing certain faces, and they're so regular, which shows that, the affection continues. Chacha, Taya, Avtarji is sitting here. He's been contributing to the prize distribution also. I mean, he's added to the prizes. So that we'll tell you later on. A welcome and a thanks, because I don't know whether I'm supposed to welcome or to thank, so I'm doing both, because this is the last function. A welcome and a thanks to all the participating teams. The judges yesterday and day before and today, everybody has said that it was difficult to make a decision. All the students were too good. So some of you will get prizes, but I think all of you will go back with something in your heart. And that is, I think, affection for CLC. You must have learned a lot. You must have interacted with other students. You must have made a number of friends, which itself is a huge prize to receive. So formal prizes is one thing, but informal prizes is another. So from the country and from all over the world, we've had so many teams, 72 teams, sir. We had started with 18 teams way back in 2005. And these 72 teams now is also after too much of pruning. The memorials were checked and some were discarded and some reached to this level. And so a big applaud for them. Without them, the competition would not have taken place. They are the ones because of which all this is happening. I would like to thank convener Professor Suman Yadav, please raise, and her team. Where are the other teachers? Dr. Rubina, Mehpara, Apanjot, I don't know where they are. Yes. All these teachers have been working day and night, but more than them, who's been working is the Moot Court Society. Lovely children that we have on the podium. If any lapses have occurred, it's because of me, because I lacked, or Suman lacked somewhere. But not because of them. Even yesterday, I think it was 11:45, at night they came to my house, scared, ma'am, 2-3 chittiyan sign karni hai. So I said, come on. So you can imagine every day, every night, for so many days they have been working. I think a very, very big applaud for them. What I have learned from all these youngsters is, which probably I don't know whether I did or not at that point of time, is selflessly work for your alma mater. That is something, a lesson, which I take back home, and I'm going to tell my younger children at home that this is what you have to learn from them. With a smile, they have been working without eating. At times, people have been telling them, you've eaten more, but they were all empty stomach. And even then, they were working. One more big hand for them. Thank you so much. All my blessings and my love to all of you and to everyone sitting here. Thank you so much. So, and one thing that I think we have to give before we ask the chief guest to speak. We did not ask our judges to give the feedback. So 10 minutes to our, sir, if you permit. No, I took a promise from him. I took a promise from him. He said, अब मैं आपके हाथ में हूँ, आप जितना मर्जी time लगाइए. So thank you so much. So ma'am, Rekha Palli ma'am, if you would like to. Thank you so much.
Justice Vikram Nath, Judge Supreme Court, Justice Neena Bansal and Justice Sudhir Kumar Jain, my colleagues at the bar, at the bench. And I think Justice Roy I saw, Justice Deepak Verma. If I miss any names, and Mr. Mr. Siddharth Luthra, Geeta Luthra, and now I know your name, Neeru Didi. Meera Didi, okay. And all the young children, and obviously Dr. Chawla also. And anybody, if I forget, sorry, because I'm speaking without a paper. I wasn't told I'm supposed to speak. But now that I'm here, I think I must start by thanking the KK Luthra Society for giving me this opportunity to be a part of such an important international moot court, which is growing, as we heard, by every year. Now we have, I think, about 80 teams, and the standard which we saw today, to all the both the teams, both of you were very good, and I can tell you with my experience, the way you were arguing, you were better than a lot of lawyers who appear every day. That says a lot. I'm heading a division bench in the Delhi High Court, and I know we have good lawyers, but there are lawyers who come half prepared as what. So your preparation and the way some of them, especially the participant from the first participant, and both the participants from second team, they did not move. That is what this moot courts teach you. We kept asking questions, they were not moving, and they were trying to answer as well as they could. That is what a moot court teaches you. When we were students, we didn't have this opportunity. At least when I was a student, there was no moot court, so we had to learn only once we joined the profession. So this is a metamorphosis for you. You suddenly change from a law student to a lawyer now. So remember, you are going to, and only one thing I will advise, you have to remember, especially to the respondents here, that when you're answering, you have to look at what the petitioner has argued. Because what is there in the file, please know, the judges will read. But you have to meet the arguments what the judges have, what the other side has said. That you were a little lacking at some point. We had to coax you to tell us and answer that. That said, the enthusiasm with which the students are sitting here is really marvelous. 3 days of moot courts, and they're still very eager to hear us and others, and also see how the moot court went. I must also compliment, I've forgotten the name of that young boy who had prepared this moot problem. Shiv Chopra. The problem was a big hand to him. It seemed like a ticklish problem, but ultimately it was a very, very good engaging problem, which a lot of us, I think, gave a lot of scope to the students to innovate arguments and come forward. I think you must take all, and I will only end by saying a big congratulations to all those who have won and all those who participated. Please remember, this is a place which transforms you into another world. It is teaching you something which will really will help you in the long run. So you make the best of it, and all the best. Thank you.
Now, I would like to request Professor Dr. Alka Chawla to felicitate Honorable Mr. Justice Vikram Nath.
I think I forgot Professor Khanna and Dr. Sethi. Sorry for that. They are the first people I need to thank. Because of them. But I had already tendered an unconditional apology in the beginning, because I said I will miss out names maybe because I was not told I'm going to speak. Thank you.
I now invite Honorable Justice Vikram Nath to deliver his address. Now, I would like to request Dr. Meera Luthra to felicitate Honorable Miss Justice Rekha Palli. I, rec- I request Dr. Daksh Lohia to felicitate Honorable Miss Justice Neena Krishna Bansal. Now, I like to request Dr. Rakesh Khazanchi to felicitate Dr. Justice Sudhir Kumar Jain. I now request Senior Advocate Dr. Geeta Luthra to felicitate Professor Dr. Alka Chawla ma'am. It gives me immense pleasure to invite Justice Vikram Nath to deliver his address.
Sorry, I kept you waiting for a minute. I was looking for a paper. I can't work without paper now. I'm used to it. Good evening, everyone present in this auditorium. My esteemed sister colleagues from the Delhi High Court, Justice Rekha Palli, Justice Neena Krishna Bansal, and brother Justice Sudhir Kumar Jain, Professor Alka Chawla. She got the maximum clapping from the students. I really. Respected former judges of the Supreme Court, learned senior advocates, distinguished professors, respected teachers, students, ladies and gentlemen, and people from the media. I can see one at least. I'm extremely happy and feel proud and privileged to be here, invited by Mr. Luthra. I tried to dissuade him not to invite me, but his smile and his persuasive arguments, failed me. This KK Luthra Memorial Moot Court started in 2005, just finishing its 20th session. and the organizers have been consistently organizing it every year without fail. I wish them all the best and thank them for being consistent in organizing it. And as Professor Chawla mentioned, from 18 teams it's now grown to 72 teams, and that too after filtering. So that's an amazing progress, really commendable. Before I start, we are all part of a family of law, whether as advocates, judges, students, teachers, or family members of such people in this fraternity. So in Gujarat, as Chief Justice, in my court, the Chief Justice court, there was a big court behind the Chief Justice seat, which reads like this. Law is the king of kings. Nothing is mightier than law, by whose aid even the weak may prevail over the strong. So that is the fraternity to which we belong, and it's a very, as every it's a very serious profession too. We deal with lives of people, we deal with properties of people, we deal with everything, right from Article 14, 21, whatever you say. So we have to be very serious in our approach, whether as teachers, as judges, as lawyers, while dealing with the subject. And this is the only aspect which can make the weak win over the strong. This is a quotation from Upanishad which has been translated and used in a judgment by Justice Gajendra Gatkar. So to start with that, now let me talk a few things about the great late Mr. K.K. Luthra. Before that, I would like to thank all the family members of Mr. Luthra who are here and who remember him so fondly and organize this moot court competition every year at such a huge level and with so much of participation, and as already disclosed by Professor Chawla, the amount of effort put in by all the teachers, the organizers and the young students. The Campus Law Center everywhere? All of you are from there only, right? Great. I do not think there could have been an ode better than this. I was reading somewhere that Mr. Luthra's father, I'm talking of Mr. K.K. Luthra, late Mr. Luthra's father wanted him, he came here from Pakistan after partition, and he wanted him to enter into government service. But Mr. Luthra was fond of law. So he wanted to practice, he studied law, he started practicing, but then his father insisted, so he appeared for the civil services, he qualified it. But still, he insisted that no. He told his father, look here, I have enough number of briefs to live, to sustain my family and my dependents and everyone. So allow me to continue with this legal profession rather than entering into a government service. His father realized that his son had already proved his worth in this field and allowed him to practice law. And then he has made a name for himself. So it's the commitment or the passion for the things which you like, you must always do in life. Remember Three Idiots? Huh? Yes. That's what he says. Whatever is your passion, you must follow it. And not necessarily that somebody else may advise you to do something like Farhan and others. You remember? Everyone remembers that. Well, I never wanted to come in law. I wanted to become an engineer, but destiny had it otherwise. I couldn't succeed in any of the entrance examinations. I failed. I wanted to go into Merchant Navy, then T.S. Rajendra, and I appeared for those exams also. There also I failed. I was not a bad student, but somehow I never got selected in any of those. So then I started doing graduation from Allahabad University. I was studying physics, mathematics, and defense studies first class student, not bad. But then something happened and I had to shift to law. But once I decided that I have to study law and I have to practice, then it was a wholehearted, all out effort for law and nothing else. I'll tell you more about my initial days and later. Now, Mr. Luthra has given me sufficient time to talk, so please bear with me, although I know all of you are tired and exhausted. But still, I'll take around 15-20 minutes, not more. Is that okay? I also came to know that late Mr. Luthra was very fond of music, poetry, and everything. And one of very famous poets of those times, Urdu poets, Asar Izhar, was a very good friend of his. So I looked for Asar Izhar. I also like a lot of Urdu poetry, and I have recited it so many places. If you find some of my, speeches in Gujarat or Lucknow, you will find me, making some couplets of Urdu poets. Anyway, there are two quotes from Asar Izhar I would like to read. तारीकियों के पार चमकती है कोई शय, तारीकियों के पार चमकती है कोई शय, शायद मेरे जुनून सफ़र की उमंग है. इसका मतलब ढूंढिएगा, समझिएगा. All these poets, use very simple words to make a couplet, but they have a very deep meaning behind them. So I leave it to all of you to look for the meaning and understand it. Although I have got an English translation, I can explain, but I will not do it. There's another couplet by him. उनसे मिलने का मंजर भी दिलचस्प था ए असर. Normally the last couplet will always have the name of the poet, right? उनसे मिलने का मंजर भी दिलचस्प था ए असर, इस तरफ से बहारें चली और उधर से खिजाएं चली. I may not have enough words to praise Mr. K.K. Luthra about how he established himself as a lawyer, primarily on the criminal side, his art of cross-examination, his knowledge, his memory, everything. But before I shift to the further part, I would like to read 4 lines for Mr. Luthra. लिखा तुमने कहा जो भी वही तहरीर बोलेगी, लिखा तुमने कहा जो भी वही तहरीर बोलेगी, तुम्हारे काम के लोहे की हर शमशीर बोलेगी, भुला सकता नहीं कोई तुम्हें, तुम जा नहीं सकते, करेंगी याद सदियाँ अब तेरी तस्वीर बोलेगी. भुला सकता नहीं कोई तुम्हें, तुम जा नहीं सकते, करेंगी याद सदियाँ अब तेरी तस्वीर बोलेगी. बहुत बढ़िया. मैं अपने आप अपनी तारीफ कर लेता हूँ. कोई अब शेर पढ़िए, बहुत बढ़िया, वाह वाह नहीं किया तो फिर वो. I have written text, but somehow I am not very comfortable reading, although the language there may be better. My spoken English is not as good as I write, but then I will try to mix up both the things and continue. Somebody mentioned about the problem which had been found by one Mr. Chawla. What? Shiv Chopra. Yes. So even when I was going through the Moot proposition, I could not help but appreciate how exquisitively it has been drafted. Straight from the police investigation report, the statement of witnesses, search and seizure memos, and the site plans. It almost felt like I was reading an actual case file, of course, a concise version. I am delighted to see that the students are not just getting an opportunity to read through such mock files, but are also researching on complicated and niche questions of law, preparing detailed written submissions, presenting well-crafted arguments, with such assertiveness. Of course, this is supplemented with long hours of hard work, discipline, and peer collaboration on your part. I can assure that these abilities that you are cultivating in the process are paving a way for each of you to become a highly skilled lawyer in the near future. It generates within you the dexterity to understand a legal problem in depth, polish the craftsmanship to develop precise arguments, and present them with a certain level of confidence when you step out of these walls of law school. I'm also pleased to know that these mock courts rooms are your initial encounters to courtroom settings and are actually serving as a playground for your skills, because it was not the same in our times. Well, our times were very different. I don't know how many of the old Justice Verma is here from Madhya Pradesh. I know he must never have attended a single class of law. See, he is agreeing to it. And so did I. Law is all about practicing. It's only then that you learn to become a good lawyer, not by attending classes and reading. So moot court, is the real place where you actually learn the skills of advocacy. And every case that comes to you makes you learn something new. Howsoever well-read you may be, every case will give you something to look for something additional. So like I said, I did law, I studied, and then I got myself enrolled. Initially, I practiced for 1 year in the district court. Then in between, I had got married. So my wife said, you have to shift to the high court. Otherwise, I don't want to be all my life wife of a district court lawyer. So I said, all right. My father never agreed to it. But then ultimately, you know who prevails at home. So after 1 year of practice in the district court, I shifted to the high court. I'll tell you before that why I went to the district court. My grandfather started practicing in 1900. He was a leading sessions lawyer in the district court. And all the bungalows and properties that we have in Allahabad is all courtesy my grandfather. He created all that. Then my Tauji was also a lawyer. My father was younger by 22 years. My Tauji, he started practicing. So they were all practicing in the district courts, civil side, revenue side, everywhere. So my father wanted me to continue practicing in the district courts. We had an established practice there. But as I said just now, that I was forced to shift to the high court, I think for better. So after 1 year, I shifted to the high court. Now my father would always say, going to the high court is like, you know, कहाँ समुद्र में जा रहे हो तैरने के लिए, बहुत बड़ा है. It's better to rule in hell than to serve in heaven. Anyway, I shifted and God has been kind to me. I have the blessings of my parents and good wishes of all my friends and relatives. So I started working in a chamber where father and son were practicing already, Mr. V.K.S. Chaudhary and Mr. Yatindra Singh. So Mr. V.K.S. Chaudhary was a senior advocate at that time. I wanted to work with somebody in the middle age, 50, 55, 45. But then I joined that chamber. Mr. Yatindra Singh also had a good 15 years practice at that time. I was happy to work with him. But he said, no, I don't have enough work, you work with my father. So I joined his chamber. But within a month, Yatindra Singh, I used to call him Yati Bhaiya. Yati Bhaiya said, all right, Vikram, you work for me also. So I started working for him. So I used to work with the father and son, both of them together. Father used to work till late in the night, 2 a.m., 3 a.m. And son, Yati Bhaiya, would get up early in the morning and start working. So I had difficult time handling both of them. One day my wife got fed up and she said, all right, either you give up one of them or you leave the chamber and join some other chamber. This is not going to work. So I told Yati Bhaiya, this is the problem, what do I do? So he went and he fired his father. What is this? Why do you keep him here so late, this, that? Anyway, I continued. After about 1 month, I got an opportunity to argue my first fresh petition. So I had no experience of moot court and all, never been to court before. I was very nervous. I still remember that court number 19. Justice MP Singh was sitting there. And we had a matter of rural sealing. So according to me and my senior, it was a good case. So he asked me to argue. My senior Yati Bhaiya was sitting next to me. I was very nervous. I gradually opened, as it may please your lordships, and then I started. And a minute later, they just said, no, nothing, dismissed. I said, my lord, kindly, no, nothing, dismissed. All right, end of the matter. A young, fresh beginner who was already nervous. My senior would tell me, Vikram, say this. निकलती नहीं थी आवाज़ अंदर से. So I said, all right, let it be. हम बाहर चले आए. Little upset, and of course he was trying to tell me it's all right, हो गया. A minute later, somebody came from inside the courtroom and said, the court is calling you. I again went back, what happened? So Justice MP Singh said, young man, was this your first case? So I said, yes, my lord. Then why did your senior not say this? My lord, that was, how do I say that, answer that? They're all right, admit, issue, notice, stay. Wow. Those used to be the good traditions. I believe they're still there. As a beginner, if you argue your first case, you get a notice, stay, whatever. The seniors used to exploit, Mr. Luthra and all do this all the time. They'll send their juniors with a dead case and say that this is the first case, and they get a notice and stay. So that was the first encounter in court I had, and that was February 88, 5th of February. So with that, I may again come back to my working in the chambers. It was hard work. I really did for a good number of years, but that the time when I actually learned law, the concepts of law, and how to draft, how to write, what to say in court. We had instructions not to be seen in the corridors from the senior. If you are free, you have to sit in court and watch proceedings, whichever court you like. Don't waste your time in the corridors or in the canteen. Lunch time is there for that, but otherwise if you are free, from 10 to 4 you have to be in court, whether you have work or you don't have, go and sit in any court and watch. Otherwise, if you are fond of reading, go to the library. Now, all of you are very soon going to pass out. Basically, my address is to the students only, and not to all the seniors here who are already so experienced, and I have been learning from them all the time. So you would be passing out very soon and would be taking up different lines to build up your future, some in litigation, some joining law firms, some going into corporate companies, and some going into teaching. But let me tell you, the challenge, the charm, and everything is in the litigation of this degree, and not in offices sitting and drafting work. No fun in that. You may get good money right from day one. As a lawyer, you may have to wait for 10 years to start earning, 5 years, 7 years. Initially, you don't get anything. Seniors don't pay. Here also, I know. But my senior was very good that way. He used to give me a check every month, fixed amount, and for every case, he would give us token amount. So we never, but not all chambers are like that. I am told Mr. Luthra's chamber is one of the liberal ones who gives. There are other seniors who take all the money, don't give anything to juniors. They only exploit them, give them work. But anyway, they make them learn, and then they become good lawyers also. So this profession gets you so many surprises, so many challenges. I'll share a couple of them with you. Have you all read about S.R. Bommai's judgment? Right? Floor testing. That's the place where the majority has to be proved, nowhere else. I was part of that great case from Allahabad, Allahabad had two very important political judgments. One was upsetting Indira Gandhi as Prime Minister by setting aside her election. And the second was reinstating Kalyan Singh as Chief Minister in 48 hours. So in the first time, of course, I was studying in school, but in the second case, I was the main counsel. And Yati Bhaiya, my senior, Mr. Yatin Singh, was the arguing counsel. So I will not talk about that. I spoke about it in Nagpur when I was there for the convocation. But I'll tell you a prelude to that this Kalyan Singh's case. What happened? Mr. Ramesh Bhandari was the governor in UP. And Mr. Mulayam Singh was the defense minister. And they wanted to upset Kalyan Singh as chief minister, somehow or the other. So what they were trying was, they wanted some kind of a direction from the High Court to the governor to decide their representation. And then the governor would take a call and call upon the other side to prove his majority. Now in that process, one evening we came to know that a petition is being filed in Lucknow and it will be taken up tomorrow on mention, and we have to be there. Now it was evening around 7 o'clock. So what do we do now? And the government wanted, Kalyan Singh ji wanted Yati Bhaiya to appear in that matter. Achha, SR Mumbai judgment is a judgment which nobody generally, comes into day-to-day matters. It's rare, this thing. And it's a 300, 400, 500 page judgment also. So we decided that we have to go to Lucknow and be there in the morning and to watch and oppose. So he set up his car, his driver and everything, and we took 3-4 torches with us. And he said, all right, Vikram, you read the judgment and I will show you the light and I will keep listening, because it's difficult for me to read while the car is moving. So we started from Allahabad around 11:30 p.m. in the night. And the whole night we traveled to Lucknow, reached there at 4 a.m. reading that judgment. Page by page I was reading and he was listening. So that way even the driver was awake and we were safe also. And we reached Lucknow because it's very risky, the 2:30, 3 a.m. you get a very strong desire to sleep, yes. So we kept the driver awake till 4 a.m. and all the torches, one by one, the battery would go, the ever-ready torches. But we managed to reach Lucknow. And the climax was that when we reached the court at 10 a.m., we were informed that the other side has withdrawn its petition. But then that reading of Bommai's judgment came to our rescue when actually the matter came up when Kalyan Singh was dislodged, and then we filed the petition in the night. Some other time when I come, I'll tell you that story. So that is the fun of this profession. You don't know when what will come. You come across, great personalities also in this profession. I don't know whether all of you have seen Lajja movie or not. Ajay Devgan. And so in that case, what happened was, that was a case about honor killing. In Kanpur district, a similar incident had happened. The trial under 302 was continuing. So that Pradhan, who was the higher caste person who had got the children killed, he filed a complaint in Kanpur court, saying that my image is being spoiled in media and this and that. So in that, the magistrate very happily summoned all of them, Rajkumar Santoshi, Ajay Devgan, Manisha Koirala, and all those film stars. Now that 482 petition came to us, not to me actually, to Justice Vineet Saran, he was a lawyer there, now retired from the Supreme Court. He and Justice Krishna Murari were working together. Then he called me also, we were good friends. He said, let's all get together. So we started working on that petition. And 482 was drafted. Now what to do? So a meeting was set up here in Taj Palace, Sardar Patel Marg. And there we met Rajkumar Santoshi and Ajay Devgan, and Amar Singh was there. He was big into Bollywood. So he was the person who was organizing everything. So we all had a 2-day conference. And then we went back, all right, no hurry, we will file it later at an opportune time, looking for a bench, not hunting, but waiting for a good bench. You see, bench hunting and forum shopping has always been there, but to a limited and a discernible this thing, not making it obvious that what you're doing, one after the other, getting it filed, getting it dismissed as withdrawn, then waiting for another one. So we were waiting for a better bench. In the meantime, Dashera vacations came. And then suddenly, the magistrate at Kanpur issued non-bailable warrants against all these accused. Then the rush came, no, we have to file it tomorrow, day after. We went to the vacation judge. He would not give us a hearing. He said, no urgency, come after vacation. With great difficulty, we were able to persuade. It was Justice Palok Basu's court. Anyway, we got an order for 5 days and then the bench came. So that was also, great fun, interacting with all those big stars, coming from a Mofussil town like Allahabad and then dealing with this. Another interesting, there are so many of them, but I'll tell you only a couple of them. I'll keep a tab on the watch also. So another one is, you remember habeas corpus ADM Jabalpur case, Shivkant Shukla? That was way back after, in emergency, this was what happening. Everyone was being picked up from wherever, and all kinds of fake and false allegations being made. And same thing happened in 1990 when Babri Masjid was, Kar Seva started. So it was Mulayam Singh's government at that time, and they were picking up everybody from RSS, BJP, Bajrang Dal, whoever was there. So then Dr. Murli Manohar Joshi, Mr. L.K. Advani, they were all apprehensive. Sushma Swaraj and all these big leaders from BJP, they were likely to be arrested anywhere. And Kar Seva was going on in UP, all over the country people were coming. Some professors of the university who were active. So Justice Vineet Saran and myself at that time, we used to sit and draft petitions all through the night because we had to file it immediately. It was winter vacation time, getting an order and protecting them. Some got arrested, petitions became infructuous. Others we could get protections. So meeting them, getting them sign those papers, sitting with them, talking to them when their petition is being drafted, it was great fun. All these big, huge personalities of this country, big leaders. So this profession is really very interesting, and you must all take a chance at least to practice for a few years, and thereafter you may still choose to not practice and do something else. I think I've always taken over, short my time. So I hope I'll not take much more of your time. I'll just conclude it. I hope that this moot court competition over the past 3 days served as an insightful journey for you all, and each of you goes back with a little extra piece of knowledge, a long, stronger conviction to work towards becoming a good lawyer, to make something good of your skills and take this country to greater heights. Before we move on to the much awaited moment of the evening, the prize distribution, I would like to call upon a huge round of applause for all those participants, students, as well as every member involved in the organization. But before that, some more couplets. Chalega? Too many papers get lost now, I have to. This is one of the inspirational ones for all of you. इतना तो मैं कर जाऊंगा कुछ अपने असर से, मंजिल को देखता हूँ मैं रास्तों की नज़र से, गुजरेगा जो भी काफिला मेरे बाद इधर से, मुश्किल नहीं होगी उसे कि जाऊँ किधर से. Oh, you can come and do that. I will not be able to. Well, their colleague, their friends will tell them. Yeah. It's not difficult at all. No, no, for the foreign students who don't know Hindi at all. Yes. Yes, yes. यही जज्बा रहा तो मुश्किलों का हल भी निकलेगा. ज़मी बंजर हुई तो क्या वहीं से जल भी निकलेगा. न हो मायूस न घबरा अंधेरों से मेरे साथी. इन्हीं रातों के दामन से सुनहरा कल भी निकलेगा. सुनहरा कल भी निकलेगा. There are two more for the lawyer legal fraternity. अदालत सूर्य है वो न्याय का जिससे उजाला है. मुसीबत जब पड़ी है मुल्क पर इसने संभाला है. All the big leaders have always been lawyers. All right? Make that, note it. अदालत सूर्य है वो न्याय का जिससे उजाला है. मुसीबत जब पड़ी है मुल्क पर इसने संभाला है. हमारे काम को देखो हमारे वस्त्र मत देखो. हमारे काम को देखो हमारे वस्त्र मत देखो. हमारी आत्मा उजली है केवल वस्त्र काला है. केवल वस्त्र काला है. गरीबों और मजलूमों के हक का मान रखती है. इट्स फॉर द कॉमन एंड वीक. गरीबों और मजलूमों के हक का मान रखती है. सदा जय बोलती है सत्य का सम्मान रखती है. अदालत दुश्मनी न दोस्ती ईमान रखती है. जहन में संविधान दिल में हिंदुस्तान रखती है. दिल में हिंदुस्तान रखती है. I think now I must run before I am hooted out. Thank you so much, and I wish all of you going back home with happy memories, and I congratulate all those who have participated, who will win a little more, and who have not. Wish them all the luck for the next year. Thank you so much. Thank you.
Thank you, sir, for enlightening us with your words of wisdom and inspiring everyone. A big round of applause for sir. Now, the most awaited moment has arrived when we are acquainted with the winners of this prestigious Moot. So I request Professor Dr. Alka Chawla to come to the podium and do the honors.
Kar do? All right. So first I'll announce for best speaker and second best speaker. The prizes are rupees 15,000 prize money for the best speaker and 10,000 for second best speaker. But along with this, both the speakers are going to get rupees 10,000 from Dr. Avtar Singh Sethi. He's the cousin brother of late Mr. K.K. Luthra. Sir, please. Both the speakers are going to get DLT legal research software from Mr. Pradeep Behel. I saw him somewhere sitting here. Books will be given by Mr. Dinesh Dudeja of Ekta Book. He has been giving it always. There, sir, please get up. The Best Speaker Award goes to Natasha Nicholson of Northumbria University, UK. They're not here. Or they've gone for a Delhi tour. So this has been decided when all the teams yesterday, they participated. So that is how the best speaker and the second best speaker prize has been decided. Preliminary rounds. They're here? Should we wait for them? All right. So I would request Honorable Justice Sudhir Kumar Jain to please give away the prizes to both these speakers. The second best speaker is Vidhi Raj or Bharati Vidyapeeth University, Pune. Come on. Congratulations. Congratulations. The next two prizes are Best Memorial and Second Best Memorial. The Best Memorial will get 15,000 prize money, and along with it the same things, 10,000 from Dr. Avtar Singh. DLT Legal Research gives the software and books from Mr. Dinesh Dudeja. And the Second Best Memorial will get 7.5 thousand prize money. So the Best Memorial prize goes to, who will give the prize? Honorable Justice Neena Krishna Bansal. Should I call the winners also? All right. The Best Memorial goes to Army Institute of Law. Congratulations to all of you. Oh, it's an all-women team. Second Best Memorial goes to Symbiosis Law School. I don't know. Team number 2246. Noida. I didn't feel like calling them by codes. All right, Symbiosis Law School, Noida. Congratulations to all of you. Okay. They were also the semi-finalists. Yes, please come.
Congratulations to all of you.
थोड़ा सा उधर जाओ, फोटो अच्छी आएगी. वहाँ जाओ और पीछे जाओ ना, सब जजेस के साथ फोटो आएगी. हाँ.
This is what you all would always carry and remember. Yeah? Long term.
They know they are going to get the next prize. But who will get the winner and who will get the runner-up, we'll take 1 minute to decide. The winner is going to get rupees 30,000 as prize money. Sir, second wala part missing hai. Mr. Avtar Singh is not giving 10,000. And DLT Legal Research Software from Mr. Pradeep Behel, books from Mr. Dinesh Dudeja, and voucher for 2 nights, 3 days stay at Alila Diva Resort, Goa from Mr. Bhagwan Parekh. Wow. Guy said, I do not know who's Mr. Bhagwan Parekh. There he is. And the runners-up are going to get 21,000 prize money in DLT Legal Research Software, books from Mr. Dinesh Dudeja. All right. So sorry for extracting, but बच्चों के लिए था इसलिए बोल दिया. All right, so the winner is Campus Law Center. The prize. और आगे जाओ. Honorable Justice I'm sure the judges didn't know that was Campus Law Center, even I didn't know it. The prize would be given by Honorable Justice Vikram Nath. सिंह अरे बाप रे सर इतने कपलेट्स के बाद runners up is Government Law College Mumbai. A big hand for them. Honorable Justice Rekha Palli is going to do the honors. Congratulations. A big applaud, please. और आगे जाओ, और आगे जाओ, और आगे जाओ. थोड़ा सा, और मैम थोड़ा सा और आगे हो जाइए. Government Law College, Mumbai. ये भी है, ये भी खींच लो और फोटो खींचिए प्लीज.
Somebody will have to pick it up. This is very, very heavy. Yeah, you will have to. I'll pick it up. No, you are.
So all the best to all of you, all happy memories. And now I ask Mr. Siddharth Luthra to please come and give a vote of thanks.
Good evening, everyone. Alka has already done my job, most of it, by thanking everyone, so I don't really have to say much. But I will begin by thanking Honorable Justice Vikram Nath. It's a fitting tribute to my late father that he has peppered, and if I may say so, peppered his conversation or his address to all of you with my father's favorite poetry and one of his authors. On a lighter note, when my father used to get a little upset with his friend for not being on time, he was never on time, Izhar Saab, he would say, Izhar, tum beasar ho gaye ho. Thank you so very much, sir. I think it's very important that our young friends here got to listen to your experiences in life. Very, very practical. And I'm very intrigued. I didn't know the S.R. Bomai case. I knew there was a linkage, but it's such a privilege to know that you've been part of that journey. Allahabad, of course, has been one of our most important high courts with a wonderful tradition and a wonderful tradition of lawyers. I dare say, I think, sir, you would also be one of those many generation lawyers. And it's a noble profession and noble tradition. The halls of Allahabad High Court speak to you if you're willing to listen. Thank you so much, sir. It's been a privilege having you here and so very kind of you. It's a very special year for us, so it's very, very, very kind of all of you to be here. Thank you so very much. Thank you, Justice Palli. Our family goes back. My late father used to speak about not only her father, but the third generation. When Sanjeev entered the profession, my father met him, Sanjeev is her first cousin, met him on the first day and told uncle, her Tayaji, and said, I can see now the third generation is in the profession. And we have the privilege of knowing this family for long. Rekha has been a colleague at the bar, a very strong opponent, and a wonderful judge. It's been a privilege to have you here, Rekha. Thank you so much for your incisive judging, and more important, the tips that you gave to our young lawyers. I will only say to my young friends, she's kinder to us when we are in her court. I will also say, so she's testing you for your best, but however, one thing must need to be said. When I see these youngsters, I'm very hopeful for litigation, but I'm very worried about old hats like me. I don't know, I don't think I would have been able to survive this problem, Shiv Chopra, or manage. Thank you so very much, Rekha. Dr. Sudhir Jain is, of course, academic, lawyer, PhD, and a friend who I've had the privilege of knowing from many, many decades past. Always academically oriented, but a man with myriad interests. Thank you so much for sparing your time and being here today, sir. Thank you so much, sir. Justice Neena Bansal Krishna is, I've had the privilege of appearing before both generations and before Neena ji's respected late father, whom my father had the greatest respect and fondness for. One of the classic cases, Swamiji, you will remember, one of the classic cases is the Anand Marg case which I was doing, which her late father was addressing. And at one stage, it's a case which has only gone on for 40 years, in 35, 40 years in trial. Justice Dr. Jain has also possibly dealt with it. And I had the privilege of seeing your father's meticulous notes and order sheets in that file. Thank you so much, Neena ji. You have been a dear friend to all of us, to our family. Thank you so much for being here today. A very special thanks to my friend Alka Chawla with her wonderful wit, humor, her inimitable style. She runs the Moot Court. She's been a convener for many years, professor in charge, a little nudge, a little push, a little smile. But Alka's a great pillar of support. And thank you, Alka, for making this 20th event possible. Alka must be thanked not only with Alka, but also her team. And her team includes not only our very good friend Suman. You have to come up here. Come on, Suman. Suman Yadav is the convener of our Moot Court Society. And all her team of academics. Great job. Thank you, guys. And along with Suman, we have Anuj Mishra, Mohit, who are, please put your hands up, who are part of the team, student conveners and their entire team. We sometimes complain about the number of certificates we have to sign off, but there are lots of these guys. Come on, you can smile also and put your hands up. It's time to smile, guys. Congratulations. Well done, all of you and all your team. Faculty and staff of CLC, who have all been there as a great support. And of course, to our wonderful participants from many parts of the globe, thank you all for being here. I'm told the Northumbria team is also on its way. Vora uncle, you better come in. You're hiding at the back. I must also thank some of the elders and friends of our family. We have the privilege of Justice Deepak Arora, Justice Amitav Roy, who are not, they have been respected judges of the Supreme Court, but for us, they are part of our family. And in all our times, our good times, our difficult times, they are always with us. And I have no words to thank you both. I know Justice Roy is going through a particularly difficult time, but I know he's had to leave ma'am and come here while she's ailing. But thank you so much, sir. I am most obliged on behalf of the family. Thank you so much, sir. Deepak Verma साहब को तो मैं message कर देता हूँ. I'd have the temerity to message sir. And he says, I know I've got the email, I'm coming. Thank you so much, sir, for coming. So very kind of you. There are many others. Gopal Dikshit ji is here, old friend of my late father's and a great aficionado of Urdu poetry. We have my uncle Anil Virmani. We have Dinesh and Rakesh Kapoor. Kapoor uncle is not with us, but the two brothers are here. And many, many others. Sanjeev Sajdeva is normally here. He's missing this year, but Shivam is somewhere here. He promised he would be here. We have an old relationship with that family, as I said. He's held up in Lucknow. There are 100+ lawyers who come to judge this event every year. We start on Friday evening for those of you who don't know on the stage. And this goes on it went on till about 1 o'clock, 12 o'clock on Friday. They were there judging till on a Friday evening. Difficult to get young lawyers to judge on a Friday evening, but they were there. And then early morning Saturday, again more difficult, and then Sunday afternoon, and of course, all of Sunday. This year is our 20th year. You know, we've come a very long way, and it's because of all of you here, all of the family, friends who support us. 16 years, my mother used to be here. When we started, Professor Khanna told me one day, he said, let's do the Moot Court in 2004. We started, my mother asked me one question. And she's a wonderful, strong woman, quiet but strong. She said, as a family, will we be able to sustain this? With her divine blessings, wherever she is, we've been able to do it. So thank you all very much for being part of this journey. We are most grateful as a family. A friend who is not here, Geetanjali Gill, has been a great support in running this Moot. She's in the UK somewhere, but I must thank her. Pradeep Behel Bhai Sahab has already been thanked. These are all people. Pradeep ji, kahan ho? You know, these people, we've grown together as families, two generations, who has been very kind to give software to the children this year, Supreme Court, all the high courts. And of course, Dinesh ji, 20 years, sir, every year he comes, he volunteers. Every student from this competition goes away with the book only because he wants to gift it, because of his fondness for my late father. Thank you so much, Dinesh ji. Alka ji has already thanked my uncle, Mr. Sethi. There are other cousins and friends. My uncle, Mr. Vermani, is here. There are doctors Lalta Shekhar is here. So many other friends. I can't name them all. But this year, there is one thing I must do. Ketki, we need you to help us a little here. There are a few people who are very special to us who we wish to honor this year. Sir, आपको जरा स्टेज से उतरना पड़ेगा आज थोड़ा. I want you to please honor my professor, Professor Rajiv Khanna, sir, and Professor T.D. Sethi to start with. And also Swami ji, आपको भी जरा खड़ा होना पड़ेगा. Swami ji from Anand Marg Pracharak Sangh is a great support and a great friend. Swami ji. Dinesh ji, we will need you up front also. Dinesh ji, also please come up. We must thank you for your kindness and your support. And Bhagwan Bhai, where are you hiding? Aage aaiye. Bhagwan Bhai, and I'll need Shiv Chopra up front also. Dinesh ji. Bhagwan Bhai, aage aaye. Thank you so much for your support. Bhagwan Parekh Sahab has been giving these lovely hotel vouchers to the winning team. I wish I could compete again. And of course, I would like to thank my dear young Shiv Chopra. Where is Shiv Chopra? Young Shiv Chopra, who's the author of The Problem. A big hand of applause. I had a lot more names, but I have been forbidden because they have all said, are we not family? And I think I will leave it at that. Thank you all, family, for being here, for supporting us. Thank you so much. हाँ जी, आइए आइए.
Honorable judges, family members, students, and the participants. Well, I have fond memories of spending some time with my brother, Mr. K.K. Luthra. He used to take me to his office. I have seen him working in his office, and I have seen him working in the courts also. And I remember on several occasions when I'm sitting there, even the opposing liars would say, we have no chance against him. He was a fantastic liar, and I would not take so much of time, but thank you very much. Siddharth is taking the legacy forward with his sons, Smarth and Soham, and his daughters, Meera and Geeta. They are doing a fine job. Today I miss my Bhabiji. She was a wonderful lady, and she gave us so much of love. Wherever she is today, we are receiving her blessings. Thank you very much. And as I promised, this is 10,000, 10,000 for no, for but here, as Dr. Alka Chawla said, she's extorting. I want to file a case against her. So, who is the lawyer who is going to... And she has admitted, and so many evidence. Thank you very much. Thank you.
With this, we come to the end of the 20th KK Luthra Memorial Moot Court. I now request everyone to proceed for high tea. As for the participants, I request one member from each team to stay back to collect their participation certificates from the help desk. Thank you. I request all the participants to collect their books as well.
हेलो भैया ओ भैया ये वाला ऑन कर दीजिए या I request one member from each team to stay back here to collect their participation certificates and their books. One member from each team. The other members can proceed for high tea, and as soon as you collect your certificates and books, you can also proceed.